This is a hearing for a group of appeals under Regulation 50 of the Water Environment Controlled Activities Scotland Regulations 2011. The appeals are in respect of notices of variation issued by the Scottish Environment Protection Agency, which SEPA, the notices sought to vary licenses of fish farms operated by the appellants, though the effect of the notices is suspended by the appeals. The appeals have the DPA references ENVE-003-33 to ENVE-003-235 and ENVE-003-256 to ENVE-003-295. But I'm not going to list all the fish farms involved, but it's sufficient to say the fish farms are located on the west coast, in the Western Isles and in the Northern Isles of Scotland. The appeals are made to the Scottish ministers. Mr. Ferry and I have been appointed by ministers to determine the appeals on their behalf. The fish farms are owned by a number of different companies. They are the appellants who are represented in the room today. SEPA is also represented, and so is Salmon Scotland, which is a trade body for fish farming. There are also who are represented virtually on to that. But just to start off with, can I just ask the parties, people who are representing the parties, to identify themselves and the people who are with them. So I'll start with Mr. Finlay for SEPA.
Yes. Good morning, sir. My name is James Finlay, King's Counsel. Next to me sits Gordon Watt, advocate, who will be dealing with some of the questions. To his right sits Lindsay Tollard, who's a senior solicitor with SEPA. Her right sits Michael Montague, who's an agriculture specialist. His right sits Paul Adams, and to his right Nina Thornton. Nina, both from Thornton's, and online should be Peter Pollard, who's a technical title as an agriculture sponsor.
Good morning. Christine O'Neill, KCI, and Uber Murray Scotland Limited, alongside my colleagues Victoria Lane and Karen Hamilton from Bodies. With us today is Douglas Hunter, the Director of Murray Scotland Limited, and online Stephen McIntyre, their Head of Environment.
Mr. McLean.
Good morning, sir. Neil McLean, appearing on behalf of Cook Aquaculture Scotland Limited, again instructed by Victoria Lane and Karen Hamilton of Produce, and there's nobody from Cook present, but we will be joined by clients later on.
I'm sorry, we don't have microphones today, so you need to keep your voice up. Mr. Welton.
I'll try. Good morning, sir. Craig Welton, Shepherd and Wedderburn, representing Scottish Sea Farms. To my left is Christopher Glendinning, also from Shepherd and Wedderburn, and Anne Anderson from Scottish Sea Farms.
And Mr. McLeod.
Good morning, sirs. I'm representing a number of parties this morning. Loch Duart, Thames, and Organic Sea Harvest, who are appellants. I do represent Loch Long, although their submissions are being dealt with in writing. We may have one point to clarify following the hearing in writing, but I think given discussions today, it has been agreed that it will be dealt with in writing.
Okay.
And then lastly, I'm representing Salmon Scotland, which, as you said, is the industry body for the fish farming industry and has a significant interest in the outcome of these appeals. To my right is Ashley McCann, and to her right is Jennifer Wells, and they are two of my colleagues from Shepherd Wedderburn.
And Mr. Mew.
Yes, I'm James Muir, KC, and I appear today for Backer Frost Scotland Limited. And on my left, we have Mark Murray from CMS, Michael Kill from Frost, and then Joanna Waddle also from CMS.
Okay, so that's to introduce the parties who are in the room. There are also two parties who are on video link to the hearing, Wildfish and Calendar McDowell. Now, I understand that Wildfish and Calendar McDowell are intending just to observe today. However, if that's not the case, please let us know now.
No, simply it's observation only.
That's good. Okay, thank you.
And Wildfish's role also is purely observational today. Thank you.
Thank you. The other thing you need to know is the hearing is being live streamed to the public. Please be aware of that if you're in the room. And there will be a recording kept of it, at least for the period afterwards as well. The appellants, the reason we're here is the appellants are entitled to appear and be heard in the hearing. They have requested a hearing, and in opening proceedings today, I'm opening that hearing that they're entitled to. And the purpose of today is to address a number of legal questions that the reporters have put to parties. And these relate to lawfulness or otherwise of the notices of variation, or the procedure by which they were made, or if that was the intention. Parties are already provided with written submission, have already provided written submissions in relation to these questions. Now, to skip forward to what happens after this session, once discussion is complete on questions we've set for today, we will adjourn the hearing. Thereafter, we will either, as discussed at the preliminary procedural meeting, we'll either issue a decision on the appeals, or we will issue an interim ruling as to how we will address the legal issues raised. And that ruling will inform further process in the appeal hearing, which we would presume. If there is to be further process, the precise form of that process will be subject to discussion with the party. So potentially today will be the end of the hearing, when we turn to the end of the hearing. So if there are motions anyone wants to make before the end of the hearing, they should make them by the end of this hearing. As regards procedure today, what we propose to do is to address each of the questions you've asked in turn in the order in which they were put. We've already had written submissions from the parties on these questions. So what we will do today is just ask the parties if they want to add anything to their written submissions. We'll generally ask the appellants first, unless the question is framed such that it's appropriate to SEPA first. And once we've asked the appellants, then we'll go to SEPA to respond to that. Yesterday morning, we started with, at the request of parties, we started with a list of points that we wanted to address. I hope it's not too overwhelming for you. Anyway, we're grateful if the parties could address that in their initial comments, or at least matters that relate to them. After we've had initial comments from the appellants, initial comments from SEPA, we can have a discussion, and generally speaking, we will, well, I think it's usually regards to the process to get the appellants the last word in the discussion. Obviously, there's quite a lot to get through today. I'm grateful if we not repeat points already made by other parties. While parties may wish to draw out points in their written submissions, obviously we don't expect them to repeat their submissions at all. I'm sure you do that. As regards precedence amongst the appellants, what I was proposing to do was simply have a rota, so she has an opportunity to speak first on the questions as we go through them. Hope everyone regards that as reasonably fair. So I would just start on my right here, so Neil, and go around. Right. Is everyone content? Is everyone content with that approach? Has anyone got any questions to ask?
Well, I do have a particular issue to raise. That in terms of the questions raised yesterday, which you said you hate that parties didn't find them overwhelming. I'm pretty SEPA's fan. I mean, there are about 50 questions, which are all helpful and informative to the matters. Of those 50, about 40 are aimed at SEPA. And some of them raise issues that the answers to which we've done have implications well beyond these appeals. Many of them we're in a position to respond to today, but not all of them, to be able to give you a full response. And just by way of example only. There are a number of interesting questions from further questions under question 2 from 7, 8, 9 and 10, which I may be able to provide you with an initial answer today, but it would certainly not be a complete answer. And the problem is that to some extent the truncated timetable is my specific fault. Being able to have a SEPA wide view on these questions and then get resolved and to give you an authority today, that's pretty difficult. Some of them require, for instance, on question 6, question 2, you've asked how exactly does the monitoring of sea lice required by the conditions relate to the license, or any variation relate to the license, relate to the conditions it refers to in paragraph 7.2. To a certain extent, that is a matter of will be a mixture of submission and evidence, to which we would again not wish to give a response that went off half court. We are definitely in a position today to be able to deal with questions 9 to 13, and let's say 14, who's going to deal with the right thing. Be able to let you stay. For instance, we would, as a matter, for example, deal with question 1 and the additional questions under question 1. Our proposal would be for those questions to us, I don't know about the other parties whose questions are shorter, would be to provide you with answers to those in writing within an agreed timescale, and to have such further procedure following that as needs be. Some of the questions relate clearly to issues that have been raised by other parties. Some of them are take those issues and inquire more deeply of them. And it seems to us that it would be difficult to pick and choose between the individual specific further questions at this stage without providing answers on the if that was your wish, Commission would be. These are interesting questions. They clearly derive from the parties' further submissions and further submissions. So we take those further submissions and inquire more deeply. So our climate submission to use that there should be impartialism of questions 1 to 8. Although there are no additional questions on question 8, it clearly follows on text from questions 1 to 7. Obviously, I'm happy to deal with question 1, which is a matter. So additional question 1 and indeed question 1 is a matter only a SEPA. If you make use to clear that one out in any event of the question. In respect to the numbers, we received in the German and progress.
Which questions exactly?
So 3 to 8.
I think just before we ask the other part of comment, it wasn't my intention to raise issues that require evidence. So I would have thought that an issue that requires evidence could simply be addressed by saying that would require evidence at a further hearing. So I wouldn't. I'll see if it can be addressed that.
So that was an example, but our main issues are such as the interpretation of our regulation 3.1G that can the licenses in question relate to so the question should relate to three specified control activities, whether those control should be whether the first activity encompasses the other two. But there are other licenses such as power license.
Sorry, question two.
Number 7 additional. These are all questions that I will provide you with it. And I'll question 7, 8, 9, and 10 so that they're all interlinked. The answer to question 7 then engages question 8, which, as you pointed out, 3.1G provides for licensing of any other activity. And then the review will have wider ramifications in this case. So I'm conscious that I would be giving it SEPA's public position on those points. Likewise, the ambit of improper approach to specific questions you ask on regulations 22 and 10.
Just staying on question 2, 7, 8, 9. He's not understood was just drawing on submissions that
but
that's not the way you read it.
I see them taking them a stage further.
I think so. What you're proposing is that today we should adjourn a discussion of question 8 and deal with them in writing. Is that it?
In writing or with a further
procedure.
That's good. I accept that they, as you let's say, that they draw on issues raised by other parties, but in our submission, they at the very least they focus those issues routinely, and they raise issues with regard implications, as I say, beyond the approach to this particular licensing procedure.
Well, I said I was starting with Sonilo, so
thank you, sir. SEPA's application for the partial adjournment is resisted on the part of Maui Scotland Limited. Maui's position would be that all of these questions can and should be dealt with at today's hearing. From Maui's perspective, the questions raised by the reporters yesterday draw on the submissions of the appellants, but those submissions themselves draw on the submissions that were made by SEPA, and they are seeking to draw out SEPA's position on a number of issues which have been with SEPA for many months. And it seems to me, sir, that the questions that have been asked are questions that could reasonably be anticipated by SEPA in preparing their original response. I'm very conscious, sir, that a good deal of investment has gone into preparing for this hearing, and if there is to be a partial adjournment, I would have something additional to say about expenses.
Mr. Welton is next. Oh, sorry.
I'm grateful, sir. On behalf of Cook Aquaculture, the for an adjournment is also opposed. I'm content to drop the submissions of Ms. O'Neill in terms of the opposition. All I would add is that this has been an iterative process. There was a pre-examination meeting on the 9th of July. The hearing was fixed on and around the 28th of August. We've known about this hearing for a period of almost 4 months. And that follows, of course, as you pointed out, process of detailed written submissions dating back as far from SEPA's perspective as the 31st of May. So there has been plenty of time in my submission to deal with the issues that have been raised, and they simply focus on what is already in the submissions. And like Ms O'Neill, if the hearing were to be adjourned on the basis sought, then Cook would have further submissions to make in relation to expenses.
So, thank you. Thanks, sir. Likewise, SSF also oppose SEPA's request, and I'd also adopt the submissions on behalf of Mary, including those relating to expenses. And just to note that Mrs Anderson travelled down this morning from Aviemore to pick up on the point about time and effort and investment that's gone in to today. The only point I wish to add at this point is, as you said at the outset of this hearing, these hearings are being held because the appellant have the right to a hearing. And my concern is that SEPA are, as they have from the outset, been resisting that approach and trying to have everything dealt through written submissions, which wouldn't be appropriate. So we also oppose the request.
Mr. McLeod?
Yes, I agree with everything that's been said so far, and I thought the submissions that have been made, including in relation to expenses. Mr. Finlay talks about the wider ramifications of this case for SEPA. Put it in context, the wider ramifications for the industry is that on SEPA's position, each operator is currently committing a criminal offence on a daily basis. And it is important that these issues are properly ventilated in public. And if that is truly SEPA's position, it's important that we hear from them and hear from them now. Now, there are several questions that are raised. Mr. Finlay says that he'll only be able to give you a partial answer to some of them. But take, for example, question 4, sub-question 2, which relates to car regulation 8.5. That, as I understand it, is a direct question from you in response to a submission made by SEPA about what regulation 8.5 says. And if SEPA is unable to answer basic questions about how it understands the regulations work, then we're in real difficulty. And I'm afraid that further time is not going to resolve the issue. So I do oppose the motion for an adjournment, and I will be seeking expenses if an adjournment is granted.
Yes, I think I can adopt everything that has already been said. On behalf of Backer Frost, we do resist the request this morning. Considerable investment has indeed gone in costs are for today. These are questions which legitimately have been posed today from reporters. It's been useful to have in advance the sort of questions to which I'm sure SEPA has time in the last several months. And indeed put down all variations around it. So I do resist, and I would seek the expenses if were any.
Just can everyone hear Mr. Yes. Sorry, because you're close to your voice up for everyone. Okay.
Do more briefly. Yeah, Mr. McLeod raised a point about question 42. That's indeed a question I'm quite in a position to answer today. As I said, there are many questions which we cannot. Mr. Welcome raised a point about the hearing. I haven't suggested there be no oral hearing steps. Making for our parties oral hearing if that's appropriate. It is the further questions that have been raised.
Excuse me, Mr. At the top hearing.
It's the further questions that have been raised, which is why we say we're in a position to proceed on the ones in respect to which and indeed trying to hide off ones where we cannot. But that's all.
Mr. Seeker and I will just step outside. So.
And in drafting these questions, my approach was I was drafting questions for myself and Mr. Ferry, and the drafting further questions. On request the parties to state what questions, to state any issues we wanted to raise, I simply said the questions. It occurred to me on reading the solutions of each of the parties. So for that reason, on Mr. Muir's point, I think these are questions that could have been put during hearing. So I don't see a reason at this point, particularly given the costs which parties have mentioned, of convening this hearing to adjourn questions to another day. I think if there is a question that people genuinely can't answer, I think the approach to take to that is simply to say why they can't answer it and what can't be answered and why they can't answer it, and we'll take that at this stage. And well, the question why they can't answer it is perhaps a legitimate issue for discussion too. So are we content with that?
So I obviously accept your ruling on that. That as I put it, transmission is not people cannot answer specific questions. It's whether we give you a partial answer or not, or wish you a more considered position. And it may well be that my response is, and I'll take instructions on this, is likely to be in the form of a very preliminary answer, which, if you would permit, we could follow up with further written submissions on specific points, if you consider that would be helpful.
I think that would have to depend on what exactly the issue was and why SEPA can't answer it. So I think we would just have to deal with that case by case as it came up.
Yeah. And in your hands. I reduce it. Let's say it's clear that all the certainly my current understanding is that specialists probably answered. So we'll do our utmost to be as helpful to you as possible.
Anyone else have anything to raise? So I was going to mention there were a couple of other business things that I needed to mention before we actually started the hearing. But just checking if anyone's got anything to raise about procedure before we carry on. So just some practical points about how we're going to deal with today. So I'm intending to run proceedings until 1 o'clock with a break at around 11:30. We'll resume after lunch about 2 p.m. and run to 4 p.m. unless it looks like we're coming to a conclusion, in which case we'll run on. I'm told the office is open until 7 o'clock. I hope you won't be here until then. If it doesn't look like we're going to conclude today, we do have tomorrow's set time as a possibility for further hearing as well. Toilets are outside to the right, outside the office. I'm afraid the front office door is controlled, so you'll need to, if you're going to the toilet during the hearing, you'll need to buzz to get back in, but maybe you'll have to hold the door open during breaks. Right. So I think I've asked everyone already whether there's anything to raise, and I don't think there's anything practical whether about that anyone wants to raise. Just looking around. No, no. Okay. So I think we'll move on to the first question, which is addressed to SEPA. This was in relation to the questions that the reporters are initially framed them, as we initially framed them, and SEPA's objection to that, which, to be honest, we just had a bit of difficulty understanding, where the objection was coming from. So what we had understood, and maybe we're wrong about this, was that SEPA's position on the interpretation of Regulation 31G was that the effects of an activity should be considered without taking account of any mitigation or controls on that activity. Whereas interpretation of Interregulations 11 to 15 should take into account controls imposed by SEPA in licensing and therefore residual effects. So is that something SEPA can?
Yes, it is. As I indicated. Yes, I think there was a misunderstanding by SEPA and a concern that the two concepts of unmitigated adverse impacts and residual adverse impacts were going to be introduced in the assumption under question two. Your further question, which alluded to Regulation 15.1, clarifies our understanding, I think, of your position, which you've just indicated, that there indeed is a difference in SEPA's position as a Regulation 31G, Regulations 11 to 15, and it's that's raised, I think, highlighted by Regulation 15.1A and B, that if there was a risk, residual adverse impact, there may need to be a derogation from the Water Framework Directive, so that the concept of residual adverse impacts is indeed exactly SEPA's position on the Regulations 11 to 15. SEPA's answer, which perhaps wasn't as precise or as focused as it might have been, was that in Regulation 31G, an assessment of whether an activity falls within 31G, the differentiate between unmitigated adverse impacts and residual adverse impacts is not a relevant consideration the SEPA had to mind in respect of the reach to 31G. So it's relevant that it's clearly unmitigated adverse impacts. If one looks at the draft questions and the further issues that you had put in at the time, you referred to both unmitigated actual adverse impacts and residual adverse impacts on the boat. And it may be SEPA misunderstood the basis of the questioning. SEPA's position is that in Section 31G don't take into account any mitigation, and it's all impacts. That would be the same whether it was under the approach to 31G would be the same as it would be to 31A when you're looking at activities now cause pollution in the water environment. Look at all activities now would cause pollution in the water environment, irrespective of the conditions that be imposed, likely to be imposed, seeking to prevent such pollution. Third point, just to pick up in your further question, in the fourth paragraph, you say if the impact of an existing activity is considered Regulation 31G, then it would seem to follow that the assessment must be to that extent hypothetical. I think we would maybe just the use of English. Well, we come on to the question of likely impact later. but the likely impact is not necessarily hypothetical.
Well, we'll come to that point.
Describe it hypothetically. We come on to that point further because you have some questions correct as to. So to summarize our response, it may be we misunderstood the import of your initial question. Following further elaboration in your further questions, I think your understanding is correct in terms of the difference of approach between 3.1G and the procedural provisions in 11 to 15, and the purposes of argument in approaching those matters than the use of the concepts that you identified as issues would seem to be reasonable ones.
Keep your voice up, Mr. Finlay.
Would seem to be reasonable ones.
What's your answer, Ian?
Yes. Unless I can put it further on.
I think I follow you. Anyone want to comment on that, or should we pass on the question to? We'll look at Mr. McLean first. So, okay. Everyone else is looking at. Okay, we'll pass on question 2 then. So, there's a simple question: is operation of a farm control activity under Farm Regulation 3.1G? Okay. I think I will ask Mr. McLean, as I said, of turning on a rota, ask Mr. McLean to address that first.
Well, sir, I see question 2.1 has been primarily a question for SEPA. Submission to cities.
Oh, who can make submissions on it? Have we written submissions on it? Is it not something you want to? Is it not necessarily in SEPA's written submissions that you want to correct?
Well, sir, one of the points I was going to raise, I suppose, is that there are the submissions that have come on the 3rd of December from SEPA with some additional comments. Do have some submissions to make in relation to those. I'm focused on the submissions, the submissions for Cook in relation to 2.1. My approach to today's hearing is really to address the questions that are related to Cook. And to make any other observations that may arise in responses given by SEPA to the questions directed at SEPA.
Question 222 deals with a Salmon Scotland position, and I felt that questions 2.1 and 2.2 could probably be read together, and I do have something to say about that if you want to hear from our side first, as it were. It really goes back to the legislative context, and probably the easiest place to see it is in the Salmon Scotland submission of 3rd December. And that I think you'll find on the joint bundle document, the updated, it's described as an updated draft bundle of submissions. I think if you go to page 29,
Yeah, sure.
and we'll take it brief because you'll have read all these things already, but 3.6 and 3.6.1 really explain the way in which the system works at the moment. And I think it's important, before we get into the legislative detail, to say that we are probably in unique territory here. This is the first time that SEPA has used its powers under 31G, as I understand it. And it's very rare to have a situation where an activity is already taking place in practice before SEPA comes to regulate. And what we have here is a scenario where to operate a marine pen fish farm, an operator requires planning permission. We go to the planning authority. The planning authority's duties are set out in the 2003 Act, and they are the same duties that SEPA has in the 2003 Act. You can find that in section 21, 22, and 25, the 2003 Act. So when the planning authority decides to grant planning permission, it has to have regard to the desirability of protecting the water environment. It's also got to exercise its duties when determining the application to secure compliance with the Water Framework Directive. These are fundamental overarching duties that apply separately to the planning authority's normal duties, if I can put them that way, under the planning regime. Now, in 361, we've said that we are not aware of any planning permission being granted for a marine pen fish farm where the planning authority or SEPA concluded that it was likely to have a significant adverse effect on the water environment. A marine pen fish farm that's operating at the moment presumably is not having those effects, otherwise the planning authority would have said so. SEPA would have said so when it was exercising its consultation duties under the planning regime.
All of them have been through a planning process, yes.
Right. I think the vast majority, if not all, but for the purposes of the discussion today, let's talk about those that do have planning permission. And what we'd said in our submission was that the fact that they'd been through this planning process, the fact that those duties had been engaged, the fact that SEPA had been involved in that process, was presumably why SEPA felt comfortable not regulating under CAR up until recently. I put that as a question to Mr. Finlay. Is that correct? The last two things that I wanted to say in relation to the duties and how this was all set up and framed. Firstly, you'll have seen the 2011 designation order, which I don't think we need to look up. We can if required. It's PDF page 311 of the legislation bundle for your reference.
311.
311, yeah. So the 2011 designation order, as you'll appreciate, imposes the duties on planning authority to exercise its functions the way that I've described, imposes the same duties on SEPA when SEPA comes to exercise its functions under the planning regime. And again, we say that demonstrates the framework within which everybody is supposed to operate. Now, SEPA says that things changed in 2024 when it became lead regulator, but there has been no change to the 2011 order to reflect that. Duties of the planning authority remain the same as they were. SEPA's duties remain the same as they were. There is no change in the legislation. And the final thing that I would add is that SEPA helpfully lodged, which is SEPA document 84, are a practical guide. I think that document is, they're lodged separately. Yeah, so you'll be able to find that in the SEPA bundle. SEPA document 84. And it's quite a helpful document in the sense that it shows the version history of it. You'll be able to see how many times it's been revised and when. And given the apparent seismic shift in SEPA's regulatory duties on 1st February 2024, and the apparent criminality that occurred from that day onwards, I would simply observe it's surprising, to say the least, that the practical guide was not updated to reflect that at the time. And I certainly say that you should take something from that, and that the operators were, until these appeals, had no idea that it was SEPA's position that the activities were criminal from February 2024.
I'm not sure, I don't want to speak for SEPA, but I'd understood SEPA to regard them as criminal from 2011, from when GAR was introduced.
I'm sorry, it's even worse than I thought in that case.
Well, maybe Mr. Finlay can address that when we come to
That's all that I have to say at this stage.
Okay. Just looking down the panel, does anyone want to add Mr. Ewing?
Just one or two short points. I mean, this is essentially, I think, the general question too is correct, whether operation of a marine and fish farm can be an activity. Well, that comes in a moment to your own individual questions, but just on the general point to emphasise, we say in the submission that there needs to be an activity, needs some specification or specificity. Because operating a marine pen fish farm is a very general description. It could cover stocked fallow, could be stocked fish cod, and so forth. The proposal, and of course, there are many activities that go on at a marine pen fish farm, which, on the face of it, could then conditions attached, because the controlled activities being called by such a general name. You're doing a list, you're hanging bird net above pens, routine maintenance, diver inspections, feeding fish, potentially pen net. I think it's not difficult to find a series of activities. And I think one of your questions, which come to later, is that operation of a marine pen fish farm covers the existing two activities specified, the abstraction of seawater and the discharge and even food and so forth. So that's if you like, a key difficulty we have with the concept of something as general as this, which lacks a common characteristic of the other activities or operations that are listed, all of which you can identify with specification, but you can't in the present case. And that, of course, brings with it a series of other problems, height enforcement, and so forth, and the lack of understanding of the operator as to exactly what SEPA and condition does appear to us, I think, that if SEPA wished to add conditions to the licenses, it wasn't satisfied that it was appropriate to do so, standing the specific activities that were on the license. We need to come up with something else, unless they've come up with something which is extremely general. That's the difficulty.
So maybe to make this clear, just in terms of answering questions, my concept was that I would give everyone a general opportunity to comment on everything that was under the question. That was my idea. Was that is everyone content to proceed that way? Or is that not? So when I moved to question 2, my concept was that you could comment on everything that comes under question 2, including the further questions. Otherwise, we might be here a rather long time if we go through all the questions individually. Is everyone content to do that?
Sir, I'm very happy to do that. I'm conscious that some of my colleagues opposite may not have understood that
Ah,
your
right.
intention, sir, and may want to come back on some of the other sub-questions.
Okay,
Question two.
Because I think we have to do it that way.
yeah,
So we can come back around the table if necessary.
sorry, I should have made that clear. Well, Mr. Muir, shall I come back to you now?
Of course,
I'll go,
yes.
go back to Mr. McLean. Is there anything that you would like to answer further in that? Anything that comes under question two? Ideas that you would address? Any falls on the question two?
Yes, sir. So I had not understood that the position. I've been proceeding on the basis you were looking for a specific answer to mission 3 from me. In terms of an overarching submission in relation to question two, Cook's position is that before SEPA can designate marine pen fish farms as a controlled activity under Regulation 3.1G, they need to be satisfied that it's an activity that is likely to have a significant adverse impact on the water environment. And Cook's position is that the evidence base to support that decision is flawed, and in respect of Cook's sites is incomplete because Cook has sites in the Northern Isles. I understand that the SEPA's position is set out in their submissions. This is a mixed question of fact and law, focusing on issues that relate to Cook in particular. In SEPA's first submission in paragraph 17, SEPA explains that it was not able to derive an equivalent threshold for sea trout from the scientific literature. Instead, the sea trout framework relies on feedback from environmental monitoring of the impacts of sea lice infections on sea trout. SEPA will intervene where this monitoring detects the appearance of adverse effects on trout populations. And that is why I say on behalf of Cook that the evidence base in respect of Cook is incomplete. And the attempt to regulate is an attempt to gather information in order to regulate position.
What's Cook's sites are in the Northern Isles?
Indeed, sir. And as the reporters will be aware, the variation notices as they relate to Cook and all other farms in the Northern Isles impose sea lice monitoring and associated reporting conditions only. I was going to respond to the comments in SEPA's response to the observations on the questions. I don't know if now is an appropriate time to do that, whether you wish to stick with the questions.
I think each party would have to. Sorry, my concept was each party would simply give an introductory. Would simply talk to everything they want to say, respond to submissions that have been made, respond to any of the questions that they feel they need to respond to, any further questions they feel they need to respond to, and so give a complete answer from their point of view and have a discussion. Is everyone content with that? Yes, so now would be the time, is the answer.
So if we go to deeper response to the submissions on the questions the reporters posed. It's actually under the heading in relation to Scottish Sea Farms Limited, which is section 3 of the response. It's 3.3.1. So this is in response to a submission made by
Just that's in sequence response, is it?
yes. So, 3.3.1. What was said there is that, as is clear from SEPA's consultation process and submissions, the issues in respect of C-TRIT have always been given separate consideration, and this is not a case of misdirection or ex post facto justification. So far as there is error in that the decision should have referred to salmon and C-TRIT, exclusively C-TRIT for those sites located in the Northern Isles. They then go on to talk about consultation feedback. And at 3.3.5, it said that there was an information session held on the 31st of October 2024, separate meeting to discuss permit conditions in autumn 2024. Especially for Cook is that SEPA's decision-making process on its evidential basis in relation to the Northern Isles is, of course, at the heart of Cook's appeal. I've already made the submission this morning about the fact that the evidence base is flawed and incomplete. SEPA's implementation of the sea lice risk framework in respect of salmon farms in the Northern Isles through services and notice of variation is premature. And I would rest on what is said in section 10 of the statement of appeal about prematurity and the consultation and responses. In the chronology, which is contained in section 10 of the statement of appeal for Cook, that describes the interactions that Cook had with SEPA as part of the consultation exercise. Cook has had no formal opportunity to respond to a consultation since September 2023, and the criticisms that are made in the statement of appeal at paragraph 10.18, more time should have been allocated for consultation in order for it to be meaningful and effective, with a proper opportunity to explore alternatives and minimise the socio-economic impacts. That remains accurate, and that remains Cook's position, as does the criticism about the absence of guidance and a proper compliance framework in relation to the reported effects on sea trade. In relation to the meeting on the 31st of October 2024, which I would observe comes almost a year after Cook's consultation response, the following observations in relation to that meeting: it was a multi-party meeting, not focused on Cook's sites or even the Northern Isles sites specifically. And if SEPA's suggesting, and I'm not sure that they are, that this meeting was SEPA's communication of its evidence base for the notices, and that is not supported by what occurred at that meeting. Any discussion of the sea trout framework was generic in nature, and no reasons were given for issuing the notices. As I said, nothing site-specific and certainly nothing Cook-specific from that meeting. There was no reference to the operation of a fish farm being added as a controlled activity. No detailed information provided about what constitutes harm to the environment. And it was noted that sea trout framework also requires modelling, which was at that point in time still not available for Shetland. And simply also note that the meeting occurred after the notice of variation was served on the 2nd and 15th of October 2020. So SEPA had an opportunity to explain its reasons for issuing the notices at the meeting, but did not take that opportunity. In relation to the meeting in autumn 2024 about permit conditions, those instructed me of check the subject of that meeting. This is the meeting that's referred to, SARS 3.3.6 of the response.
Right, okay.
Those instructed me to check the subject of that meeting. It was entitled Sea Lice Standstill Condition. And as the reporters will be aware, Cook has no permits with standstill conditions, so the meeting is irrelevant and certainly doesn't provide any further justification for the decisions that we're taking, or was any separate treatment or strong evidence base in relation to the impact of trout in the Northern Isles. So those were the comments I wished to make in relation to the observations. There are other comments that are directed at Cook in that document, but I propose to pick those up as part of the questions. So that was the later one.
Okay. On in respect of question 2, Mr. Wilding.
SSF also have sites in the Northern Isles, so take this opportunity to endorse Mr. McLean's positions on that point, because what he says on behalf of Cook applies also to SSF, and they share the concerns. The only additional point I'd like to make on that in terms of the evidence base is that when SSF were served with the notices, the variation notices in respect of the sites in the Northern Isles, the email from SEPA attaching those, which is from the 11th of April 2025, from Mr. Lockhart, said it lists all the sites, and then it says, we previously sent you email of 24 December 2024, the relevant decision document pertaining to SEPA initiated variations when we reissued earlier variations. The same decision document provides further information on these variations. Please note that there was only just one. Sorry.
Tell me what you're reading from.
So it's an email from SEPA. I have to say, I don't know which document number it is. It was submitted as part of the original appeals.
Right.
It should be clarified. Yeah, it can come. It's the email from SEPA attaching the variation notices when they were served.
Okay.
11th of April 2025. We'll confirm the document. Sorry. It says the same decision document provides further information on these variations. Please note there is only one decision document covering all the variations, which are listed in Annex 1 now attached. And this is simply to reiterate a point that SSF have made already, which is that that decision document referred to and considered only impacts on wild salmon. There was no consideration of impacts on sea trout. And that is, if you recall, sir, the appellants were asked to put to SEPA various points on which they felt further information was required. And one of the points put in respect of each of the Northern Isle sites for SSF was evidence of impacts on sea trout. And SEPA didn't respond in substance to that point. As I understand their position now is that the decision document either meant to include sea trout in it or should have been read as saying sea trout was included in it. I think that's a retrospective explanation, and I think actually what's important is to consider the position that SEPA had in front of it time it issued the variations. And I'm conscious, so you've got a lot of submissions from SSF and others on question 2, and I don't want to repeat everything we've said on it. The only other point I wish to add just very briefly in terms of the nature of the activity is a point I think we and others have made in terms of SEPA has referred to activities identified in CAR, in Schedule 3 of CAR, such as the keeping of livestock, the operation of sheep dipping facilities. And I think it tries to draw an analogy between those activities and operation of a marine fish farm. And as others and we have said, really, those are activities undertaken with the operation of a farm. And I think that would be the more appropriate comparison would be operation of a farm as compared to operation of a fish farm. And it is not operation of a farm that you find in the regulations. We did, in our submissions, raise the point that if SEPA, because the other distinction that can be made there, of course, is that these are all activities that are listed in the regulations. So an operator, a terrestrial farmer, knows that if he's operating a sheep dip, that car is engaged, and he knows the rules and the parameters that exist around the operation of that sheep dip. We've got none of that here. And one point we did pose was, did SEPA consider a variation or an amendment to the regulations themselves so as to include the operation of a marine pen fish farm, or a variation of that, as there's various suggestions on that, be added as an identified activity within the regulations, because that, of course, would give some notice to people on exactly what regulations cover and what they don't, and the parameters when a license may be required or not. As things stand, we don't know whether a marine pen fish farm without any fish is called one fish, or a certain tonnage of fish. And it's not clear if SEPA did investigate an amendment to the regulations, and if not, why not? And if it did, why it wasn't taken forward.
I'll agree with everything that's been said. I'll maybe just add one point in relation to one of your specific questions. So question 8. I think it goes on to what Mr. Welton's just been saying. So you asked, can a license lawfully be granted for an overarching activity under CAR, encompassing several activities that fall within other letters of 3.1? I think our answer is no. So to take the example, or to take the live example here, SEPA appears to say that operation of a marine pen fish farm is the overarching activity. There are some activities that are clearly already regulated under CAR, abstraction and discharge. And if you look at Regulation 30 or CAR, this deals with consolidated authorizations. And it says that if there's more than one authorization applying to controlled activities which carried on. Can you just give me a moment? Sorry, sir. Yeah, it's a really short point. So Regulation 30, consolidated authorizations. If there's more than one authorization applying to controlled activities which are carried on by the same responsible person or operator, SEPA may replace those authorizations with a consolidated authorization subject to the same conditions as the authorizations being replaced. The critical point there is it's more than one authorization applying to controlled activities. So, for example, and I think there are examples of this, you could have one authorization that deals with abstraction and discharge, separate controlled activities. Your question, I think, is a more general one, which is, could you have an overarching operation which would control things? And our position is, no, you couldn't. You have to. The document can list specific controlled activities, but you can't have the overarching description. And we come on to that, look at that issue in more detail in other questions later.
Just on the specific questions that were posed yesterday, just to pick up on the two, if I may. The third one, only G should be included, A to F. All those would agree. Yes, it should. I mean, the colour comes from the activities, the dimension qualifications that are mentioned in 8. Case law about that point. Number 5, how is it possible for an individual to tell what actions fall within the ambit of offence? That is a concern, I think. It's not quite clear where, again, SEPA, I think, anything involved in the operation is no longer prohibited, but operates encompassed in the general term. The concern is that demonstrates over-regulation. So 6, we would say that it isn't. It doesn't bring legal certainty because it doesn't identify the activity that SEPA truly protects is the direct or indirect sort of significant adverse impact. I made the point, I think, a little earlier that, in effect, in 7, it is authorising the same activity twice, it appeared, because it's duplication, the general particular. The 8, I think, it's just been mentioned. We agree that.
So sorry, just on that point, that's permissible or not permissible?
Well, it's over-regulation, duplication. It's getting to existing specified activities and specific overarching point, which goes back to what I was speaking about. So on 8 and 9, I think we've answered no. It's in the regulation and it's not an other activity. In the research. Right. 10, I think you refer to SEPA's response. It's 2.157. They say they can't impose conditions in relation to an aspect of operation because it involves significant adverse impact, which is, as you sort of put it, why not just name the relevant aspect? Has been some what I think was described as clarification by SEPA. They said, well, what we really mean is fish farm where there are wild salmon and there's etc. Well, it's not an aspect of an activity. That is an activity. So it is that if they can clarify it now, why didn't they specify the activity at the point of issuing the variation? So I think we would answer 11, 12 positively with the sentiment of questions.
12 is, I think, my narrower definition that SEPA, well, the potentially narrower definition coming to SEPA submissions that they come on.
Yes, yeah. I'm not saying that it's correct, but in principle, the obligation to define it narrowly, that speaks to legal certainty of the law, but it also assists the operator to know actually what is being regulated. What a short point on 13 is use of the word discharge. I think dispersal belongs to look at.
Oh, okay.
See, I think would be, I think, dispersal because the natural crustaceans that they disperse. Actually,
I thought I think that from black frosts. Dispersal was the worst.
very briefly at 15, the question of the reporter's power to alter the controlled activity more narrowly defined. I mean, in principle, of course, because they firm variations with modifications. I would suggest many other hurdles would need to be overcome for that disposal of the law. Boring words would say it's a caution, let's SEPA revisit that. And then finally at 16, you asked whether there's no power deviations under regulation 2 is not just a procedural error, and this seems slightly to into a discussion about substantial prejudice and procedural error.
Actually, I think question 16 should be asked on the next question. I'm sorry.
Well, we'll have to hold it over at that.
Yeah, but it's quite pleasant to you.
And then just briefly on SEPA's final comments about parties' responses. I think SEPA say at paragraph 4.3.1 in their comments with respect to Baker-Frost's so paragraph 2.9. SEPA don't really engage with the point that they have to be satisfied not just that there's impact, but there's significant adverse. And I picked up a reference also to unnatural increase of sea lice. My submission, if we're looking at unnatural incidents, then they have to look at the man-made operation, which is mitigated. Mitigation has to be taken into account because the companies any interference which they say has an unnatural increase.
We'll come on to that.
Yeah. Their comment.
Oh, sorry. Yeah.
It depends on another.
I think it's more question 3 issue, is it? Question 4 issue.
Question good. That's why I wanted to add.
Great. Coming to finally to Neil. I think before you start, I think we're getting towards 11:19. So if we hear from you, Mr. Findlay will have a lot to think about potentially. So we take a break, 15 minutes, and then.
Thank you, sir. To answer question 2 directly, Murray's position is that the operation of a marine pen fish farm cannot, as a matter of law, be a conflict regulation G of regulations. And sirs, you will appreciate that this is a core question for these appeals, because if the appeals are correct in their submission, then what has been done by SEPA is outside the bounds of the regulations and must be in our submission watched. Murray's submissions on this question are set out in section 3 of the 24 November response, which runs from page 391 of the joint bundle. I don't propose to.
So sorry, could you?
391 of the joint bundle of submissions, sir.
Thank you.
The submissions, in summary, rely on a number of principles of statutory interpretation. The first of which is that the activity of operating a marine pen fish farm is too broad in scope and lacking in specification. And what flows from that are the submissions that are made on behalf of Murray about the principles of legal certainty and that penal provisions should be construed narrowly. Now, the principle against doubtful penalisation is something that the reporters have picked up in a number of the additional questions on question 2. Murray's submissions and those of Cook refer to the Good Law Project on that issue and make reference to a number of paragraphs of both the first instance and appeal decision. I would like to take the reporters just to some of those paragraphs that are not specifically referenced in the submissions. I have got page 183 of the authorities bundle in front of me. And this is the Good Law Project at first instance under the heading of statutory interpretation.
You've 183 you wanted to look at, yeah.
183 of the PDF.
Yeah.
The internal page numbering.
Sorry.
Slightly different.
Oh, is it? Oh, yes, it's just 183 of the PDF.
The index takes up about 4 pages of the but I'm looking at 183 of the PDF. I don't know if you
the 183 at the bottom. It's not the electronic.
It's 175 at the bottom.
Yeah. Oh, what's it? Oh, yeah.
There's a heading a little down the page, statutory interpretation, and I do just want to commend these paragraphs to the reporters, and I'll read them. Say for one point, there is no dispute about the principles of statutory interpretation. The basic principles are that the words of the statute should be interpreted in the sense which best reflects the ordinary and natural meaning and accords with the purposes of the legislation. It is generally possible to assume that language has been used consistently by the legislature, so that the same phrase, when used in different places in a statute, will bear the same meaning on each occasion, all the more so where the phrase has been expressly defined. Now, I mention that point because it's relevant to other submissions in this appeal about the approach that SEPA appears to take to the significance, the impact, the risk of significant adverse impact. Their position from the appellate side would be that where that is used in the regulations, it should bear the same meaning generally, save for exceptional explanation as to why it should be different.
Acknowledge that.
Yes. It's also generally reasonable to assume that Parliament intended to observe what Bennion calls the principle against doubtful penalisation. This is the principle that a person should not be subjected to a penalty, particularly criminal penalty, except on the basis of clear law. And our submission would be that the regulations cannot be read as allowing for the imposition of such a broad and general activity as the operation of a marine hen fish farm. And then there is a discussion about electoral or referendum expenses, which was the subject matter of this case. In these circumstances, counsel for the Electoral Commission and Vote Leave both submitted the definition of referendum expenses should be construed strictly, and any ambiguity or doubt about the meaning resolved in favour of a narrower interpretation so as to avoid doubtful penalisation, and Maui relies on that. And then there's a discussion about whether this principle should be one of last resort. And what the first instance divisional court says is, we think the position was fairly stated by Mr. Justice Sales in Bogdanich when he said the principle of strict interpretation of penal legislation is one among many indicators of the meaning to be given to a legislative provision. It is capable of being outweighed by other objective indications of legislative intention, albeit it is itself an indicator. Wait. Now, in that passage, it seems to me that the divisional court is simply saying this principle is one of many, and you weigh it with everything else. When one gets to the Court of Appeal, the Court of Appeal takes the view at paragraph 78 of its judgment that the divisional court had not given sufficient weight to the principle of doubtful penalisation. It regards it as a principle to be given significant weight, and that is, as I say, is at paragraph 78 of the appeal judgment, which is at 210 of the PDF.
Oh, right.
I don't know if porters want to look at that.
Well, I certainly would say so.
So I simply observe that the Court of Appeal was in no doubt about the significance of that principle. Maui's submissions also rely on a number of the points that have been made on behalf of other appellants, including that any other points in Regulation 31G should be interpreted as applying to activities that share common characteristics with activities listed elsewhere in Regulation 3.1, and the case authority is given for that. So without then repeating everything that is in the written submission, to pick up the reporter's questions from yesterday or further questions from yesterday, in my submission, question 1 is principally for SEPA as to why it did not apply controls for the 1st of February 2023. And the second question was principally for Salmon Scotland, and Mr. McLeod's already picked that up. So question 3, I've just addressed that the Regulation 3.1G should be interpreted in light of the other activities in Regulation 3.1. And in relation to question 4, that's dealt with in Maui's submissions at paragraphs 3.11.1 to 3.11.6. Sub-question 5 is effectively about this principle of doubtful penalisation, which I have already addressed. And I would pick up one point, sirs, from SEPA's response. SEPA appears to say that it does acknowledge the implications of there's a question that it has not been regulating an activity which it considers has been criminal for some time. But in essence, its position is that the appellants ought not to worry about that because SEPA isn't proposing to take enforcement action. And one of the reasons why it's not proposing to take enforcement action is because its enforcement principles require a degree of intent and foreseeability. And one must assume that SEPA is acknowledging that the appellants could not have foreseen that this activity was regarded by SEPA as criminal and could not have had any intent to be acting in breach of the regulations. And if that's correct, in my submission, that supports the view that Regulation C1G isn't a proper basis on which to assert a controlled activity as broad as activity, the operation of a marine pen fish farm. It couldn't be foreseen.
Can you just remind me where that is in SEPA's submission?
The point about foreseeability, that is at paragraph 3.15 of SEPA's November response. Sorry, I think in relation to the other sub-questions, I'm content to rely on the other appellants have said. I would just pick up on the very last, which is 16. This question about whether...
I was suggesting we should leave that for...
Oh, I'm sorry, you did.
Question 3 or question 4.
My powder dry on that. And that remains, that's what I see for 11:29. That's all I would say on questions.
Okay, well, it's 11:29 now. We'll take a 15-minute break. And just going back at 11:45. 45, so I'm looking at Mr. Finlay. And so just before we start, Mr. Finlay, I was going to just say that, as I said, the question 16 is better, the further question 16 is better dealt with under question 3. And question 13 and 40 were moved to sort of front question very on back. So where it says discharge, that should be dispersal. So very clever.
So what I'm proposed to do is make some overarching submissions which may pick up some of the points and then go through the detailed questions, try and pick up points I haven't dealt with, then finally respond to those points that have been made against us that I haven't yet dealt with. And no doubt I shall miss something out. Can I stress the assumption, which I'm sure either you nor Mr. Ferry will forget, upon which this question is based, that is, sea lice dispersing from fish farms are likely to have a significant adverse effect on the water environment. Now, that's a hotly disputed matter between the parties, but that is the assumption on which this question needs to be answered. And that would be the same for salmon farms as well as Mr. McLean's trout farms. The second point having regard to that is my understanding none of the appellants suggest that that harm would be caught under any other subparagraph regulation 3.1. So leaving aside the specific definition of the activity, if you didn't catch that outcome under 3.1b, it would not be caught. So I understand there, because it's not, for instance, pollution, where parties agreed sea lice aren't pollutants. So that if you were to allow that activity or that outcome, if I can call it an outcome, distinguish it from activity for the moment, to occur without people being able to take action under the CAR regulations, that outcome could not be prevented under the CAR regulations. So, jumping ahead of myself slightly, in answer to the point, do you interpret regulation G as something additional to otherwise within A to F, unless it provides for some additional control of the outcome that I've just indicated? So in our submission, on any ordinary approach to statutory interpretation, G is a standalone provision. The next overarching point I wish to make is that there are two converging timelines in this opinion. One is SEPA's understanding of the position, notwithstanding the stress I've made on the assumption. I placed it on the assumption. SEPA, I understand, concluded in 2021 that for the purposes of CAR, the weight of evidence warranted identifying an activity as an impact likely to have significant adverse effect on wild salmon and sea trout if uncontrolled. So that is a matter of scientific evidence, which is hotly disputed. It didn't jump straight in to regulate it. It consulted on doing so, which the consultation process you have, which has been significant, and ended, which again was hotly debated, whether the conclusion it reached was appropriate or not, and that may ultimately be a matter for you and Mr. Ferry to determine. but it has sought, contrary to the shrill voices from the other side, to take that forward in a structured and appropriate fashion, not jumping to penalisation, but to consult on its view. And then there is a regime under the framework that gives force to that view in a structured and in public way. It has sought to provide comfort to the operators that there will not be retrospective prosecutions. And in that regard, I can leave. So Neil referred to our paragraph, I think it's 315 of our first response. As has happened on many occasions, a reference to SEPA position has been taken and exaggerated, but essentially SEPA's position is that it sought to offer comfort to the parties that there is going to be no representation, and it's a matter SEPA has discussed prior to today, and it had hoped to have a further comfort letter, because it's noted the responses from the other parties saying they didn't feel they had sufficient comfort. Further letter will be sent to parties, appellants, seeking to clarify those points. A copy will provide it to you. The second timeline, which I might take a little bit on, is SEPA's the identification of SEPA as the legal authority by the Scottish Government in this area. And could I take you to SEPA's production 2? Right. So this is the Scottish Government's response to the it's always tempting to pronounce it SWIG, but SIWG, and electronic page 3 and actual page 3, there are 3 bullet points. First, makes it clear that SEPA, the lead body responsible for the managing the risk to wild salmonoids from sea lice and fish, and it will consult on an adaptive spatially based risk assessment framework, which is what it has done, albeit science for being. One goes on in the document those are the headlines. To electronic page 8. One notes in the second paragraph there's a jointly agreed recommendation for a step change in how the risk of sea lice transfer from farm to wild fish is managed. They agree that the regulatory regime should be fast, transparent, enforceable, and enforced. Then in 2019, as an interim measure, can ask you to metaphorically underline the words interim measure, we delivered change at the local level by advising that environment management plans should be standard for any new consent. So that is clearly, the environmental plans are meant to be an interim measure pending the outcome of SEPA's process. Then in the next paragraph, SEPA has the power to control any activity which directly or indirectly is likely to have a significant impact on the water environment. There's no doubt the Scottish Government considers 3.1g as a standalone power and capable of dealing with this issue. I'll come back to the precise definition of the activity in due course. Then the next paragraph, short paragraph repeating a point I've just made, SEPA will become the lead body. And then a regulatory technical work group has been developing an adaptive spatially based risk assessment framework to facilitate the management of sea lice interactions. SEPA will take forward the further development of this framework, which will be applied through the car licensing regime. And then in line with the last paragraph on that page, in line with our commitment to streamline the regulatory framework, is our intention that local authorities will no longer be advised to include EMPs as a condition, and instead SEPA will become responsible for regulating those interactions. Then over to the following page. It's intended the proposals involving increased numbers of fish farmed, including etc., will be assessed under the new spatially based framework, and where there is a potential for interaction subject to conditions appropriately limiting their contribution to lice loads in coastal waters. Reporting requirements to inform assessments of cumulative risk from proposed and existing developments will apply to existing fish farms through their car license. Now, I'm not suggesting there the reference to existing fish farms justifies our choice of the activity as a marine pen fish farm, but it certainly, that is the target of the general target of the government's approach. No doubt these regulations might. Now, of course, the government could be wholly misunderstood their own regulations, but in our submission, that's not the case. Those are the matters. I mean, obviously the whole document's important, but those are the specific matters I wish to draw your attention to in the document. If you then go on to, I think it is production. It's not production 84. Production 86. This could be a very better my original. Yes, Russian. 86 of it. I just need to production 86. Just open that up. So this is clearly bringing the matter. Suggesting there were no steps in between them, but this is bringing the matter more up to date. And so I can ask you to turn on to electronic page 19 of 41. There's picking up the second half of the response. SEPA's sea lice risk assessment framework has been designed to assess and manage this risk, and that refers to the risks identified above. All proposed fish farm developments, irrespective of location, are subject to an appropriate risk assessment. This assessment concludes a development is incompatible. SEPA will not grant authorization. And again, it's all proposed fish farm developments. And then in the next response, which goes over from page 19 to 20.
These are the minister's response.
Yes. We delivered change at the local level by EMP should be standard for any new consents. And then reading short, but picking up the next paragraph, with the implementation of SEPA's sea lice risk assessment framework, we expect EMPs relating to the management of interactions between sea lice and fish farm and wild salmon lice will be phased out by the end of 2025. Now, that is obviously being hopeful in the light of these appeals, but so that you have those two competing timelines. First of all, SEPA's, and not just SEPA's understanding of that underlies the assumption in this case, but then their role as lead organizer and the fact that temps are going to be phased out. And obviously, whilst that process is going along, there may be stages of duplication, but the clear direction of travel is that, and that is why SEPA takes the position in its regulatory process that it is going to be the lead regulator. Car licenses are going to be the license that regulates this. Whatever other interim measures, and I use that word advisedly, are in place at the moment, should not impact on that because their license in the future, the interim measures, actually for the past, if we can oversimplify it in that way. The third strand of the background is to refer to the authorities that as Neil referred to earlier, the Good Law Project. Those you need to go back to them. But you'll recall that the Divisional Court approved a summary from Mr. Justice Sales, technically as he then was, he's now in the Supreme Court, saying the double penalisation principle is one of a number of principles. There is nothing in paragraph 78 of the Court of Appeals judgment which cast doubt on it. They may well have given it more weight than the Divisional Court in this back to that particular case, but the approach, certainly on simply responding to the submissions this morning, appears to be the one that is set out in the Divisional Court, and that's the approach which we suggest you should be taking.
Also, the first instance.
Yes, first in Divisional Court's first instance. But it certainly, and my understanding of the Court of Appeal is that there's no criticism of the principle which the Divisional Court applied, just the application.
Yeah. There's various principles of statutory interpretation.
Yes.
This is one of them.
And can I say, in terms of statutory interpretation, I can't remember which. I think it may well be the Brady's submission, if I that way, for both have set out some very basic principles of statutory interpretation by reference to Supreme Court authority. They're not disputed. There are many principles, but one of the approaches to interpretation of the regulations, which you have to bear in mind, is that these regulations in effect emanate from the Water Framework Directive. Apologies if I call it the Waste Framework Directive, the Water Framework Directive, which has, and I won't take your time this morning going through that in detail, but it requires member states, and still does, to put in place regulation to deal with, amongst others, issues such as this. That is, first of all, incorporated within the statutory framework by the 2003 Act. And that Act in section 20 uses the terminology activities without defining it. So the definition of activity is an issue that is raised, is a concept that is a statutory definition, a statutory concept, rather than just a concept of the regulations. And one can also note in Schedule 2 to the Act, again, there's no need to turn it up, but in Schedule 2, which is referred to in
2003 Act.
2003 Act, one of the purposes of the regulations are to further define the activities, modify the definitions, or specify other activities. And I also understand that the particular terminology of 3.1G has been carried forward into the new regulations, whose name escapes me for the moment. But whilst parties are agreed, these appeals are determined under the car regulations. The same issue with the new regulations is my understanding. Turning then to the regulations themselves, and particularly for these purposes, Regulation 3, there are a number of the appellants suggest that G is the only generic matter. Most of the subparagraphs deal with generic activities. So if just concentrating for the purposes of my submissions on Regulation 3.1a, activities liable to cause pollution for environment, it's liable to cause, it's not dealt by way of result. It's looked at if the same argument that was advanced by the appellants under G were advanced under A, it would be given incredibly short shrift. You should be not licensing. You should, before you consider whether it's an activity which should be controlled under the regulations, you should have regard to the mitigation that was intended. You look at the activity. If that activity is liable to cause pollution of the water environment, it should be regulated. You will then decide what conditions to put in place to control the regulations. Similarly with G.
Do you have a question with that? It'd be helpful.
Yes, absolutely.
Ask that now. So just on that one, firstly. So, and this is really slightly half-formed thought just on the basis of what you're saying. D1A has a kind of expression of likelihood in it. Yeah. So it's activities liable to cause pollution to the water environment. And D1G also has an expression of likelihood in it. There's put slightly differently. But is there not, even for 3.1a, although it's specific about activities, it's not activities that cause pollution, it's activities liable to cause pollution. It express a different degree of likelihood. But wouldn't you take account of what was done to ensure that the activity did cause pollution and determine whether it was liable to cause pollution?
With respect, in our submission, no, because that would undermine the purpose of the regulations and not comply with the purposes set out in the Water Framework. Just come back to G to answer the question. You're assuming that there is likely to be a significant adverse effect on the environment. Now, different parties may put forward different forms of mitigation in different cases. You either regulate, I'll use the answer to this question, SEPA's approach, marine and fish farms, and seek to control the interaction of lice on wild fish, or you don't. If you had to have regard to each individual fish farm's mitigation proposals, there would be no consistency and there would be no certainty, because you need to ensure that those mitigations are enforced. I'm hesitant to use the planning analogy because the planning system framework is different, but you have conditions in planning permissions. If you were to permit a polluting a waste incinerator, that is an activity that's liable to cause pollution of the air. You can permit it on the basis that you have imposed conditions, and those conditions are enforceable with a variety of sanctions. If you considered you didn't have to grant planning permission because the the mitigation would be put in place anyway, it would be a bizarre situation because there'd be no way of enforcing those. So in our submission, you have to look at, particularly under 3.1a, and I agree with you that whilst expressed differently, they refer to there's an assessment of risk in both cases. In 3.1a, perhaps it's even closer. They are activities which are liable. In our submission, that should read, if not properly conditioned, to cause pollution to the water environment. Now, under the Water Framework Directive, if they were going to cause pollution, even notwithstanding conditions, and slightly jumping ahead of ourselves, you could obtain a derogation. But if you didn't include that activity within a licensed framework, in our submission, you would be fundamentally failing in the state's duties under the Water Framework Directive. And the same for 3.1g. Right. The word activity is used also, it's used throughout the regulations, but various activities are effectively identified in Schedule 3 of the regulations in terms. If one looks at Schedule 3 of the regulations, under column 1, you have activity, and then there are a number of numbered activities, and then rules. And perhaps the important point to stress today, that if you were an activity but not complying with the rule, you would need to apply for an authorization. It's almost like a permitted development. To use an exact planning analogy. But if you comply with the rules, you don't need an authorization. But if you don't comply with the rules, you would do. If I can then, in that regard, turn on to identified activity 19 and 20. One is the keeping of livestock, and the other is cultivation of land. I think in one of your questions, you asked whether we consider that a marine farm is equivalent of a terrestrial farm. For sake of argument, it might be considered that farming could either involves, in generic terms, the keeping of livestock or the cultivation of land. I think there's anything else that would come within farming. Certainly not a general farming nature. You either cultivate land or keep livestock, or you do both. So terrestrial farming.
I was thinking maybe a farm shop.
That would be an ancillary activity. You're not farming. So your keeping of livestock and the cultivation of land are effectively combined, would be a terrestrial farm. The marine farm, you don't cultivate the sea, except perhaps when you grow mussels, actually. But the marine farm is to an extent the equivalent of keeping of livestock. And if I come to your specific further questions, The keeping of livestock as an activity might well involve working in a farm office, administering staff pay, or administering the movement of livestock. And you'll know there are significant controls on the movement of livestock. Or recharging automatic feeders for livestock, or repairing fencing for fields. Under additional question 5, those are all, I'm not going to call them activities, but operations, to try and distinguish them from the technical useful term activity, that would be inherent in the keeping of livestock. And there would be similar operations inherent in the cultivation of land. But for the purposes of these regulations, that doesn't mean that the keeping of livestock is not an activity. And the regulations have to be interpreted as a whole. In our submission, the keeping of livestock, if that is a sufficient, if Parliament has identified that as a sufficiently specific activity, terrestrial farming, then keeping of fish in a marine pen fish farm would be analogous and specific enough for current purposes. One is looking at question 2 for whether the approach to activity has been undertaken in a reasonable format, and in our submission, the appellant's submissions either ignore or downplay the requirement to read the regulations as a whole, which includes the specific identification of these activities as activities under the regulations. To answer your question 4, additional question 4, is the operation of a marine pen fish farm analogous to the operation of a farm? Yes and no. Yes, but operation of a farm would include cultivation of land. But given that that is not a realistic option at sea, then the operation of a marine pen fish farm be more closely analogous to the keeping of livestock, which is a specified activity. In our submission, the generic term activity, there was no need, I can't remember which of the parties from Woodburn made this comment, but I suspect it may have been Mr. McLeod. There was no need to amend the regulations because activity is a broad term used in the statute, continued within the regulations, and on the assumption made, subject to precise definition, is entirely appropriate to deal with the harm which this SEPA is intended on engaging with. The number of questions in the original question 2 on the criminalisation, and I've answered that in part, but in our submission, it is inherent point we have made expressly, but I'll repeat within the regulations, that there may be activities which, whether under, for instance, under 3.1a or 3.1g, that had not been identified as activities, that would either pollute in terms of 3.1a or have a significant adverse impact on the water environment under 3.1b that may, for want of a better word, be discovered. In any such case, if it was determined that SEPA is correct and that the assumption is correct, then the logical consequence of that would be that the activity had been, in principle, unlawful from the moment it had been first initiated. That is inherent within the regulations, that is not a risk. That the risk of prosecution is obviously not one that is be taken lightly or lightly dismissed. But the ability, if someone such as SEPA were to seek to force against fish farm operator, where the issue is highly contentious as to whether the assumption is correct or not, on the basis of if they're again, on shorthand, any prosecution would be an abuse, because that be particularly contentious in the circumstances of this case as to whether there was a significant impact. And SEPA has recognised that, coming back to my timeline, by consulting on it, and then by putting position in place in the way it has. And I referred to the letter of comfort that we're seeking to provide. But in answer to your questions, SEPA has said yes, effectively. The theoretical implications are as you have identified. But in our submission, it's inherent within the, to just stress that one point, we provided our answer to question 2 in some detail. It's inherent in the regulations that the concerns that have arisen in this case will arise. And the concerns about prosecution, my understanding is that they have certainly been heightened by the parties in the course of these appeals, and weren't their initial responses to the draft variations that were sent out. I don't wish to downplay the fact that they're concerned, but SEPA has given it's got its enforcement principles, and Mr. Neil has referred to them, but in terms of intention and foresight, that they are, it is highly unlikely. But I don't want to give a further comfort letter on the hoof, but it's highly unlikely to prosecution. But that will be, as I say, subject to a letter of due course. So yes, under question 2A, there are those issues, but in my submission, that shouldn't drive your interpretation of 3.1b. It would apply to 3.1b. Because if you had an activity that hadn't been thought to be polluting, but equivalent to sea lice, was subsequently discovered to have been polluting, that is an activity that should have been licensed from the outset. If the advance of science and or knowledge demonstrated, and there's a dispute between the parties as whether the advance of knowledge has demonstrated the risk of sea lice adverse effect on the water environment. But it is that SEPA would say that growing knowledge that requires it, or has led it to seek to impose licensing, or to bring the operation within, the activity within licensing to impose conditions to prevent such harm arising. The same would arise if the scientific knowledge or understanding of a pollutant, some substance that wasn't considered to pollute, but subsequently was transpired it did. I then turn, those were the overarching submissions I wish to make. I then try to questions briefly. I don't know whether I'll try and deal with them sequence.
So just continuing the analogy with 1A, you're saying 3-1A if scientific knowledge advanced, then actually enforcement. So they wasn't a fact. Are you essentially saying that has changed its view on sea lice?
Well,
and therefore,
I think I said at the outset of my submissions in 2021, SEPA concluded that the weight of evidence warranted identifying. So yes, that is. I think some of those parties listening said SEPA was slow to come to that realization. But SEPA, not in this room, stands a little between two groups, if I can call them that. Some saying that SEPA should have been taking more active steps to deal with this issue, and some saying there is no issue to deal with, summarising each party's case. But SEPA came to that. But I do say that in terms of the risk of criminal prosecution, it is inherent within the statute, because neither 3-1A nor 3-1G, or indeed, I haven't looked at the others, but 3-1A doesn't have a time frame on it. It would be, in retrospect, it's not necessarily the right word, but it would, as soon as you establish that knowledge exists to prove the activity was polluting of the water environment, there would be potential liability under 3-1A. I think the point you just raised is indeed picked up under your further question one. Why didn't SEPA apply controls in respect to sea lice before 2024? The answer to that is in by reference to the two time lines that I alluded to earlier. One is SEPA's understanding that it should be dealt with from 2021, and the other is that it effectively from 2024 was adopting the role as lead licensing and undergoing extensive consultation, so that it didn't bring these changes in abruptly. It is consulted on them, which it appears in part to being criticised. But in our submission, it has acted responsibly in that sense throughout. The question two, personal bar, I think it was raised in a very specific fashion by someone in Scotland. There's no issue of personal bar here. Grant of a licence does not give rise to personal bar. There's no statement of fact that which we're resigning from. There's no prejudice, given that certainly none been identified. The licensing scheme permits of licenses that can be varied and activities added. And personal bar in our submission would run into significant, if not insuperable, problems when you're trying to prevent a statutory body undertaking its statutory enforcement. And whilst personal bar had a brief life in the English planning jurisprudence for enforcement notices, it's been effectively, significantly, if not wholly eliminated. For the latter reason that planning authority might have said, we're not going to take enforcement action, and that might have given to a legitimate expectation in England. Broadly, personal bar in Scotland, certainly the same concept. underlying concept involved. Whilst I think it was Lord Denning that gave some air to that, the subsequent courts have made it absolutely clear that the planning authority cannot limit its role as an enforcing authority acting responsibly. So personal bar is not an issue, and if my own friend for Scotland wishes to develop that, then I would respond to that. It was an unspecified comment in their December response. From my submission, that's not a matter that really concern you, sir. Question 3, I've answered that already. Our answer is no for the reasons I've indicated. Shouldn't be interpreted equivalent to 3.1a to F. One just needs to look at Schedule 3 for the range of activities to be included. Question 4 I've answered already. And indeed question 5. All those operations under question 5 would apply to keeping of livestock, suitably translated. The SEPA's answer to this is that you license the activity, you control it by conditions. Those conditions must be imposed for a purpose for which SEPA has a power, which is effectively prevention of harm to the water. Activities or operations outside that are not controlled, not be capable of being controlled under a license, albeit the activity itself might embrace wider functions. And the keeping of livestock or cultivation of land are absolutely on-point examples of an activity that would create wider operations or function. The question 6 deals with the good law project cases, and I've in part I've dealt with those cases in our submission. The approach of set out that serves as the correct approach, and it is not there are other statutory laws for statutory interpretation, and one is to look at the mischief, and one is to look at primarily to look at the language of legislation, which has been the basis of SEPA's submissions. Question 7 is a question I noted earlier. I can only give a preliminary or partial answer, but in our submission, there is no reason why a license is incapable of authorizing the same activity twice. But if you are against us on that, then the and were concluded that the activities of B and C under that cross license were included within A, the short answer to the appeal would be to treat this. That's correct. The reason why I paused,
But we might need to look at whether we get power to do that.
so I think you would be varying the license of the authorization.
It was going to notice for each. I suppose we have to amend those for each to.
The next variation move those if you were going to impose it wider. But the reason why I'm it's a preliminary answer is that the B and C are specific activities that may or may not be comprised every with so are like every marine pen fish farm, but they're like some other matters as well. These are also uh, issues that would arise in hydro scheme license consents, where there are a number of specific activities within the same scheme. The question of authorising the same activity twice may be one that I know friends have raised, but if so, I missed that. But our submission is that it could be, because the whole licensing procedure contemplates something can be both a pollutant and have an adverse impact on the water environment, irrespective of the pollution. There's nothing inherently inimical to the scheme of the legislation to either them describe them separately or describe them under one activity, if that activity was, that description was appropriate. Which moves, I think that deals with, I think I have anything more to say about 8 or 9, but those are the one I believe I've covered. So that you can only impose conditions, restrictions, pursuant to your purpose of the regulations. So you couldn't control working on others. You can just, if the decision in the farm office was actually related to the ocean, for instance, it would be a related matter, but you're not seeking to control that, you're seeking to control the activity to have an impact on the water environment. So you're not seeking to help control how somebody works beyond that. As to 2 and 11 and 12, and in principle, you should be looking to define your activity not as narrowly as possible, but as precisely as is reasonable. And SEPA considers that and this to some extent does touch on the difference between discharge and dispersal. No farm operator sets out to discharge sea lice into the water environment. It is a byproduct of an unwelcome byproduct down fish farming activity. And in our submission, it would be wrong to define the activity by reference to the outcome. In question 12, you pick up on SEPA's suggestion that the controlled activity might be redefined as the propagation of salmonid in the marine fish farm. Can I make I understand a point, theoretical point has been partly theoretical, it's been made in respect to other fish. Now the fish are farmed at the moment, but some licenses do permit whitefish. And certainly, again, my understanding is if the marine pen fish farming was qualified by a reference to salmonoids, then that would be an appropriate qualification of the activity. There's no intention to cover whitefish farming. That point aside, in our submission, there's no reality, no difference between the propagation and cultivation of salmonoids as part of the operation of a marine pen fish farm and a fish farm. So a fish farm is all about the propagation and cultivation of salmon. It's saying the same thing. And that's what we said in our response. We don't think that that would add anything. And if you were to think that was a more appropriate description, then on the basis that we don't think there's any difference between the two, could have claimed if you amended it to that, then our submission there is no difference. What you're looking at is the keeping salmonoids in a pen which has the unwanted byproduct of dispersing unnatural quantities of lice into the water environment that could impact on wild fish. Discharge just has a very specific understanding in the context of environmental law, and really usually refers to discharge of pollutants, which is no doubt why other parties have been concerned. I think dispersal is, but the dispersal to the water environment of sea lice larvae is a result-driven definition rather than it's not an activity, it's a consequence of an activity.
You had asked a question about this, and you responded.
Yes. Question 14, would the definition have to include reference to the activity's significant adverse effect on the water environment? No, with respect, wholly misplaced. It's considering outcome as opposed to activity. And the same, you wouldn't define the activity under 3.1a as an activity by reference to the fact that it would be liable to cause pollution to the environment. The license you refer to identifies the specific potential pollutants, but you don't identify the activity by reference to the outcome, which would be pollution of the water environment. I just see whether paragraph question 16 will leave. In response to question 15, I think I understood Lanford and Mr. Muir to seek to potentially row back in it. We understood Ackerford's position to be that you have very broad powers under the regulations on appeal with respect to if there were adjustments to be made, you could make them. Let me make it absolutely clear, because some of the appellants seem to latch on misunderstandings. We consider marine pen fish farm. Primary position is that marine pen fish farm is an appropriate description of the activity. So, in light of your questioning, we've suggested an alternative explanation. We don't consider that definition by reference to outcome as appropriate. We don't think that there is any significant difference between chosen and our alternative formulation. But you do accept some potential criminal consequences, that the activity should be clearly defined, as should the license. Can I then turn to the various submissions made by the appellants? I think a number of them, including Mr. McLeod and Mr. McLean, were referring to matters of evidence, and what was said at what meeting is not the subject. It's the subject of my submissions to you today. We stand by our submissions. Mr. Welton made a point about decision documents. I think we, in our suggested in our response. So I'll start again. Mr. Welton made a point about decision documents in the context of trout farming. In our response to it's the 3.3.1 of our December response. I reiterate the contents of that, which are that sea trout had always been given separate consideration. And poor Mr. Welton suggests that it hadn't, belies the consultation process, which clearly had regard to some of the sea trout. But it's our case that we didn't need to give reasons for the decision. But if there is an error, it's that the decision document should have referred to salmon and sea trout, particularly sea trout for sites located in the North Isles. And that would be the error, that it should have done that. We'll come on to your powers again in due course, but if reasons are given and the decision document needs to
Sorry, you're not hearing.
My apologies, I lowered my head. If the decision document is in error in failing to refer to sea trout, and if there was a legal obligation to give reasons to that, it's a matter that can be corrected. It's clearly to suggest this is ex post facto justification. Mr. McLeod drew attention to Regulation 30, which allows one to consolidate authorizations. In our submission, that doesn't really help. You can have one authorization covering a number of activities. I don't think that actually helps you with the question about whether one activity can encompass another activity. Our solution is no principle. I covered all the other points in my answer to you. But in summary, the identification of marine cone fish farm as an activity under 3.1G on the basis of your assumption is a wholly lawful approach.
Just following up on the question about, I know you gave me an answer, please, perhaps expand a bit further. But in terms of certainty, would it not be easier to simply change the law to make marine fish farming an activity, a defined activity in the 2011 regulation?
It would have been a potential option. I accept that, of course. But I've taken you to production 2 where the Scottish Government made it clear to SEPA they considered it had the powers under the power regulations to impose controls. They refer to fish farming. They weren't specifying the precise route that SEPA could take, but considered that the regulations in that current form enable SEPA to do it. And I return to my initial question: if this harm is to be catered for within the regulations, which it clearly should be, then there is we are not doing any damage to the wording of 3.1G to include an activity which gives rise to that harm. I reiterate, the activity should not be defined by reference to the harm. Easily, SEPA says that it has defined the activity with reasonable precision and appropriate.
Before we start, we're now at 12:52. I said we would break for lunch at 1 o'clock, or about 1 o'clock. Do people want to continue now for a period, or would it be better to wait till after lunch to address Mr. Finley's point?
I wasn't actually intending to respond directly to Mr. Finley at this stage. I was really just going to give him an opportunity to address one point that I raised, which I appreciate he's had a lot to deal with this morning, but he omitted to deal with the point I raised about the 2003 Act, which is the origin of car powers that we're here to discuss today. And if I could maybe put the point in a slightly simpler way than I did this morning, you've got my submissions on what it does, but does SEPA accept that the duties in the 2003 Act that it's purporting to exercise now are the same duties that the planning authority has to exercise when granting planning permission? And if the planning authority's already done the job of protecting the water environment, does SEPA accept that that must be taken into account for existing activities that are there today?
I can deal with that. The question ignores the second timeline which I alluded to, which is the transfer of the fact that planning authorities were doing it on an interim basis. SEPA are intending to do it on a base, envisaging a world, licensing in a world where EMPs are phased out. So general duties do apply, but the responsible authorities under Section 2 must exercise their functions to ensure compliance with requirements and directives. That's the overwhelming duty. But they obviously have to have regard to what other authorities are doing. In these circumstances where SEPA has been directed by the Scottish Government to be the lead authority, it would be bizarre if my learned friend Mr. MacLeod's point was to have any substance, that SEPA should not approach its licensing provision on it would be the sole licensing authority, but temper its licensing approach by reference to what is happening as an interim process. Now, it would obviously might be relevant to other functions such as enforcement, but we're not here discussing enforcement. We're discussing the identification under Regulation 3.1G of whether this is an activity that should be included within a variation, and to suggest that that definition or approach to activity should be tempered either under this question or other questions by what is happening by way of an interim process would defeat the process the Scottish Government directed SEPA to undertake.
Question of others, but Mr. Cloud, does that answer your question?
Well, it raises multiple other questions, but I feel like you asked your question, sir. I could maybe come back on it after that.
I just wondered if SEPA is relying on the action received from the Scottish Government, what status does that direction have? So I hadn't noticed.
If we were being judicially reviewed for not, with respect, for not carrying out our duties under the legislation, then in my submission, there's nothing at odds with the scheme of the legislation taken as a whole. Scottish Government to identify a lead authority. If to ask planning authorities to put in controls on an interim basis, which would then be phased out when SEPA's regularised its position. If the suggestion is that that is a breach of statutory duty, that would be primarily a matter for the Scottish Government to answer. But in our submission, it is not. It is entirely consistent with a coherent approach to the administration seeking to comply with your general duty to ensure that to secure compliance with the requirements of the directive, one body, it's a lead body. And whilst that body is putting its house in order, can have other bodies carrying out interim processes. There's nothing inconsistent with that.
But it's all I wanted to understand was SEPA is an independent regulator. Does it take instruction from the Scottish Government? It has a separate duty on regulations to enforce the regulations.
It does. I don't, at the moment, I don't understand there to be any tension between its duties under the Act and becoming lead authority. Mr. MacLeod's approach, and that of others, is tantamount suggesting that SEPA should be ignoring the fact that when their licensing procedures are put in place, planning authorities will be encouraged, if not directed in due course, to discharge or not enforce environmental management plans, which is the clear indication from government. And for SEPA to have to approach its that is entirely consistent with securing compliance with the directive that you have a lead authority. And it's not, I don't understand there to be a tension between the two. So yes, SEPA is an independent regulator with specific duties under the Act. But if, as part of the coordination of those duties, the Scottish Government identifies it as an authority, I suppose SEPA could say, no, we won't do that. But it hasn't done so.
So if SEPA was addressing environmental management, it takes the view that it's imposing a new system without environmental management plans. Surely did not, in respect to the fish farm, propose the new system at the time the environmental management
Well,
is ruled by section 42 application.
frankly, you need one system in place before you remove the other system. And I mean, my understanding, for instance, there's a meeting next Monday to discuss about this very topic, about the phasing out of environmental management plans. That, as you can understand, that is slightly torpedoing the process of that by these appeals. Not a complaint about the appeals at all, but it's just a statement of fact. There would have been more certainty about that now had these appeals not been taking place, is my understanding.
Does SEPA, I posed the question at my first submission. I've made a submission that, as far as we were aware, no planning permission has been granted in circumstances where SEPA has said there's a breach of the Water Framework Directive, or there has been, or the permission would allow significant adverse effects on the environment. Two questions, I suppose. One, is SEPA aware of any? I think we probably would have heard that out. And question two is, if they're not,
Well, that's, we're assuming for the purpose of this question that there is a significant adverse effect of water environment but for mitigation measures.
well,
That's what you're getting at.
we may come back to it in that case when we come to address the planning regime in detail. I thought we were talking about the mitigation in terms of SEPA's licensing conditions, but I mean,
I'm happy to respond to that in brief, which is I don't believe we are, but SEPA, that's the first timeline which I spoke to, is that SEPA is putting in place its regulatory framework by purpose of a consultation process, realizing that the underlying basis of it is clearly disputed, as the underlying merits in these appeals demonstrate. And it has decided to do it by the route it has. In our submission, SEPA has approached that responsibly. If it is in derogation of its duties when responding to specific planning applications, that may be. I don't accept that it is, but it doesn't impact on the decision that you have to make.
So you had a second question.
it was really that let me put it slightly differently. SEPA's assessment of the likelihood of significant impact depends on it ignoring completely the effect of existing planning permissions. Is that correct?
That's with respect to Mr. McLeod, which is a simplistic approach. It's been SEPA's position, which I've reiterated today, purposes of identifying an activity, that you consider the activity without mitigation, which is, as I answered in respect to question one. So to that extent, yes. But and when imposing conditions on a license, slightly getting ahead of ourselves, SEPA takes into account, has to approach the matter on the basis that environmental management plans will be phased out. So if it were to take into account the controls under those plans, it would be in derogation of its duty to ensure compliance with the Water Framework Directive, because it would know those plans were going to be phased out, but wouldn't have controls in to replace them. So it would be a nonsense for SEPA to, with respect, let the controls under those management plans influence its decision-making process at either stage when it knows those plans are due to be phased out. Otherwise, there'd be a lack of control.
Allow discussion to run on this, although I think it's maybe nice with the future question. Shall we're at 1:04 now. Should we break for lunch now, or I think it's probably a good time?
Could I just add one point? Just I've received by way of there are working arrangements, but SEPA wasn't a consultee to those working arrangements. So I've just been asked to make that clear until its framework was in place. So the working arrangements.
2009 ones.
I believe so. I'll come back. Perhaps I'll provide you with full detail of that part.
Yeah.
But it may be that those instructors being concerned about something I said, but subject to receiving instructions on that, and those are well answers.
So I don't know if it's really got the point.
No, I've just obviously I've had a comment by email on something I've been making submissions on.
Right.
It may be there will be other comments over lunch that I should have added, particularly in respect to those questions where I said I was going to your preliminary questions.
Sir, could I raise one housekeeping matter before we break? I had an assumption that we would conclude at 4 o'clock this afternoon. I've heard what you had to say this morning, and I raise it because I had committed, perhaps unwisely, to a meeting at 4:30 from this building to another meeting at 4:30. But given where we are, I am now operating on the assumption that it's highly likely that we will be back tomorrow. I appreciate that's for you, sir, and Mr. Ferry, but I wonder if you might give us some indication of whether you.
I'm sorry, I was actually going to say that yesterday. I think you tell your families that you're in for another day. Yes.
We say we'll finish at 4:30.
Yes, we can totally finish at 4:30.
I'm very grateful. Thank you very much.
Right. Okay, we'll break for lunch now, unless there's anything else.
As I was just, we started to realise microphones weren't on for watching. So it's made a submission in respect of the phasing out of the ENVEs. As I understand it, the proposal is that ENVEs should be phased out just for the interaction of fish farms and wildlife respective.
In the wording of the letter, it's between the interactions between sea lice from fish farms and wild salmon.
Right.
It's electronic page 20 of 41.
Right.
Up to 86. Well, I had read that out beforehand, but I then referred to phasing out of EMPs more generically without that caveat that that was the context in which those comments should be clean.
Right. So I think where we take it here is reactions or questions in respect of the submission. Is there? So just going to look at you complete the balance anyway. Just catch my eye. Mr. Muir.
Just one or two short responses. It did to me, this is the thing was accepting that it might be more specificity and did to be in Parliament. I think yes, it might the keeping of sunrise in fish farms. To me, I think to others that when it comes to looking at what generic which stems to control utility and regulation of force things can carry on or shall cause or permit others to carry on for activity except insofar as it is authorized in these regulations. So if the operation of our marine and fish farms are generally stamped with the descriptor activity, then what you had on you would be in breach of the regulations unless you went as you had obtained an authorization. So it's wait to the necessity to define the activity to profile the wild weather or sediments. The only other point, just on EMPs, I think it would be, I think it would be bizarre if see more the extent of the measure. Response is something less than another question. It does go to the question of coordination, regulation of the strategic plan. Because I think European Union was 2021. We decided that this was the sources of the same kind. Knowing that there would be a transition, one is suggesting that there should be, if you like, the ELPs are withdrawn and there's no new procedure. What now, of course, is duplication over a period. And what I understand from SEPA's documents, the reality is that it may take some years before they are satisfied about the evidence to impact. And so we are talking about a period of many years to the 2020s. This respectfully appears to me that this is a units on SEPA to ensure coordination with other agencies. I see no reason why they shouldn't be specific endpoint at the start point. Starts with scope next to some asset or already. So this on the other issues what we live with is the uncertainty and satisfactory aspect of the regulation, possibly for a number of years. These are my observations.
Sorry, I would associate myself with what Mr. Muir has just said about the scope and breadth of the controlled activity, and it goes back to the question about doubtful penalisation. Mr. Finlay said that he had addressed that question. In my respectful submission, he did not. In my respectful submission, what he addressed was the proper legal test for whether the principle of doubtful penalisation applies, but he didn't address how it comes to be that in his submission, this broad controlled activity is compatible with the principle. And building on what Mr. Muir had just said, if there is a narrower way of expressing this, then that is the way in which it ought to be expressed, and expressing it in a broader defence against the principle of doubtful penalisation. The other observation I wanted to make, sir, is in relation to the exchange you had with Mr. Finlay about Regulation 31A and 31G. And you had asked the question, even in respect of you take account of mitigation measures to prevent pollution. And I have Mr. Finlay noted as saying that SEPA would not do so. And it would not do so because if you had to have regard to each fish farm's mitigation measures, that might lead to an absence of consistency and a lack of certainty. My response to that is that each licence and each licence holder is an individual case, and in each case, SEPA ought to be addressing the facts on the ground when applying the legal test. And in my submission, what was said by Mr. Finlay was that in respect of each of Regulation 31A and 31G, those regulations are to be read as including the words absent mitigations arising from conditions. Now, in my submission, there's no basis in the regulations for reading that in, and there's no logic in reading in absent mitigations arising from conditions, square brackets, but not any other mitigations that might exist, close square brackets. So in my submission, that it either has to be all or nothing. SEPA has regard to all mitigations when exercising its powers under Regulation 31A or 31G, but it can't read in some mitigations and not. The only other point I wanted to make in response was 2 points, in fact, in relation to the phasing out of EMPs. It's my understanding that where a planning permission currently contains a condition about an EMP, that condition will remain in place, even if EMPs are phased out for future licences. Those who have EMP conditions will continue to have them, unless and until the holder of the licence or the planning consent makes an application for that to be varied. They can't drop off as a result of anything that SEPA does, is my understanding of the position.
Well, the planning authority has discretion whether or not to enforce, doesn't it?
Well, yes, sir. I have some difficulty with the arguments that are being made that operators are to rely on the goodwill and generosity of regulators not enforcing in terms of their consent.
Is the judgment in accordance with the development plan, as material considerations of that level?
As may be, sir, but I think operators are entitled to have certainty about what their conditions are and what they mean and what they might be held to account to comply with. So those EMP conditions will not simply drop off, even if there is a progressive phasing out of EMPs for new applications.
They can be removed as well by Section 42.
But as I understand it, that must be operator initiated.
Yeah. Okay. Just one point on that, I've discussed this. If the EMP conditions were to be replaced using the Section 42 mechanism, actually anybody could make that application. Indeed, SEPA could make the application on behalf of the operators to ensure consistent regulation and avoid double regulation.
So there's an interesting suggestion. Maybe not what I need to resolve, but it's a.
Well, I don't think you do need to resolve it.
I don't have anything else to add.
Can I just clarify some points in respect to that? With respect to miscellaneous, our case on 31Gs is not to be read absent mitigation arising from conditions, but including other mitigation. It's absent any mitigation. And yes, SEPA do address the facts on the ground when they impose conditions, but we're mixing and matching two stages. And lastly, I may have misunderstood Mr. Muir, but SEPA is about timeline. SEPA is satisfied now, subject to your determinations, unfortunately, that there is adverse impact, and they are hoping their regulatory framework has not been challenged. So the EMPs, the phasing out of the EMPs, should be occurring by the end of 2025. Should have occurred by the end of 2025, according to Mary Gouchon's letter. Will now be passed for. We're not waiting years for that to take place. It's meant to be taking place once the organisations are enforced, which they aren't at present. So I don't understand why there should be many years before one control, or the handover, if you like, EMPs to our licenses takes place. It's certainly not our understanding of the position.
You want to address the back on the condition release and in the issue?
Yes, with respect, it's not down to goodwill or generosity. If the planning authority sought to force such a condition in the context of SEPA, relating to the interactions between sea lice and fish farms and wild salmon assuming, for instance, for these purposes, that the variations are in place, that would be an abuse of their powers, because Murray or Cook or whoever could quite rightly complain that the planning authority was not meant to be engaged in that. That was for to be engaged. So whilst I don't know how, and it's not primarily for SEPA to determine how the planning controls are going to be phased out. That is primarily a matter for the Scottish Government and the authorities. But as I think I indicated this morning, there is a meeting on Monday at which SEPA is attending, where that issue is a topic for discussion, if not the main topic. It's not something it's something that's been contemplated, and it happened, I understand.
The new shift that looking puzzled by doing the biggest submission on the person.
I think I've probably said all that I can, so.
Two points, or maybe one point, some points. I think Mr. Finlay said that SEPA's position is that there is adverse impact from sea lice. That's SEPA's position. And just to clarify before I go on, actual adverse impact or likely adverse impact?
Mr. McLeod knows our case that it's likely adverse impact.
Likely. And likely with effect from the date the variations were served, or likely with effect from the date that mitigation under the planning regime is removed?
I'm not sure I can answer that question directly, but if SEPA is correct, that has likely been the case. In fact, I think we have asked, it's likely been the case since 2011. I don't think what has changed, in my understanding, is our knowledge and understanding interaction between lice deriving from green pen fish farms and wild salmon. It's not that that interaction hasn't been occurring throughout time period. So if that harm has been occurring or likely to have occurred, reference to Mr. McLeod's position, it's likely to have been occurring for some time. It's frankly relevant to the question you have to ask as to when precisely that harm did begin to occur.
Well, Mr. Finlay set up my sub-point quite nicely for me, because speaking to Mr. Muir earlier, he has a copy of a new document that he was going to seek leave to lodge. It's a SEPA consultation document that was issued, I gather, on Monday this week, and it's called Safeguarding Scotland's Water Environment. If I may, I'll just read briefly from one paragraph. This is what SEPA says as of now. We now need to focus on gathering additional information necessary to understand the effects of sea lice from existing marine fish farms on wild salmon and sea trout. We expect this will involve several years of data gathering. Where the evidence collected shows significant adverse impacts on wild salmon or sea trout, we will ensure appropriate and targeted action is taken. And so I think Mr. Muir will be in a position to lodge. I have a copy as well that I could submit. Be helpful. But in general terms, our position is that SEPA has gone far too early here. We have an existing regime that protects the water environment. We understand that SEPA was told that it should become lead regulator for sea lice. At the moment, there is existing framework of regulation under the same legislation that SEPA operates under. And at the moment, SEPA still does not have the evidence it needs to be able to show significant adverse impact. That's the terms of its own document issued on Monday.
It isn't, with respect.
Doesn't say that.
I have it in front of me.
They do it.
I'm sorry, sir.
Neither do I. But the point is that SEPA, even in its consultation exercise, doesn't suggest that there is not more to be learned, or that there may be a difference between showing likely impact and actual impact. And my understanding of the River Basin Management Consultation, which is the title of the document, is that it is looking at that issue and the evidence of actual as opposed to likely impact, and then the steps to be taken to reduce actual. So it is entirely consistent with our position, but this is straying into the merits.
Well, or at least into a further question about whether evidence justify. And I think it was a further question respect to the justification is
So it's a question on
question 7, isn't it?
Yes.
We did the activities over the region, but the first place based on materials which it did have regard to sea lice regulatory framework. Can we come back to that?
Yeah, certainly, sir. And apologies for referring to a document you don't yet have. I think there are some hard copies that could be distributed if Mr. Finlay's okay.
Managed to go ahead.
No, it may be that we'll want to make specific submissions on it once I've got the copy. I think, but useful if we had a hard copy.
Do you have any others?
Just one, I'm sure, would be sufficient for us, because others will be able to.
Returning to question 2, is there anything further that people want to say on question 2? I think we've had Mr. Finlay. If anyone wants to respond further to Mr. Finlay's submissions, So I would also say we'll give the appellants an opportunity to have the last word on this question. So do any of the appellants want to have a further word on it? Nobody's looking at me. So shall we pass on to question 3? So, broad question, whether the operation of the marine tank farm can lawfully be added as a new control area variation in existing license under our activity. Obviously, we've had submissions on that, and I've put down a number of further, for which we can add question 16 from the previous one. Obviously, quite a long heading. I said at the start, whether it's finding this as congenial as it might be, but I said at the start, I would give the thoughts of that first word. So I'm going around and talking to Mr. Wells.
Thought it might be an meeting. I've thought about this and seen how this morning SSF submissions on question 3 were set out. It's JB 240.
Do you want us to look at those? Or?
I'm happy to see it was read, sir, because contains what's there. And then there, in terms of response to what SEPA had to say, JB 252. We did have a look at the supplementary questions, and despite those, most of them seem to be for other people. We've done for SEPA and others. I don't want to duplicate, but there's one that's directed at the appellants generally with 3. And SEPA. Try the best way to doing it. Question asks, is it the appellant's position that no change can be made at all to the description of the authorised activity? And I was mindful this morning that things have been done in the abstract. Most of the submissions have been in the abstract, and it might actually be helpful to look at an actual license and authorization at this point. There isn't one in the bundle. I don't think one's been loaded. I wondered if the best way of doing this would be, they've all been submitted.
Is the one in one of the appeals?
So I went to one of our own, which is for NPFF owns Geo Site 3, which is the reference for it is ENVE 003-297.
Okay, I'll get that.
It's a very long way around to make a short point.
Tell me the last one again.
277.
277.
It's the second document. First page, variation of notice dated 16 April 2025. You got it? Thank you. The what is electronic page 5 of my copy, which is schedule 1. That details duty of the authorised persons 1.1, and then it details the authorised activities at 1.2. We're seeing here authorised activities are A and B.
Yeah.
And it's really just it's a long way around to make a short point, which is in our submission, you could rely on regulation 22 to amend the detail of what you find at 1.21 A and B. So, for example, the extraction of more than 10 cubic meters per day of seawater could be changed to 15 or 5 or 20, and that is something that could be done under regulation 22. While you have that in front of you, and in the context of conversations about keeping of livestock and keeping of fish. So this morning, look at the next page, Schedule 2, which is effectively conditions to the license. It says that there are the species of fish, and basically the amount of fish, the weight of fish, and then issues about fallow period and restocking. So that's controls that have been imposed on the operation under the existing licenses without recourse to 31G. But in terms of question 7, that's the short answer. Is in our view, you can use 22 to make minor variations because sort of thing that we picked up there. We'll draw a distinction between that and adding in an entirely new authorization. It's just a different point.
So it's not so in terms of section 22 or regulation 22. I'm sorry. What you can do under regulations is not necessarily limited to removing, adding, amending any condition of the authorization. It's also, you could also amend the description of the authorization, the description of the activity rather.
Yeah, and my interpretation of this is that these are two separate activities that are authorized.
Yes.
And so what regulation 22 allows you to do, so it's two separate authorizations, apologies, in the license. So what 22 allows you to do is vary authorizations there. I don't think 22 goes so far as to allow you to add an entirely new authorization to an existing authorization. That's what regulation 10 to do.
When raised this, but perhaps the strings of learning, Mr. Finlay referred to the operational ring pen fish farm as being kind of encompassing description, which you could get rid of those two activities and just kind of operational fish farm. Would that is that another way of conceiving it as a kind of redescription of existing activity, part of redescription of existing?
I think so that you in your questions and in a question to Mr. Finlay have identified the difficulty of that, and Mr. Muir's already raised or made submissions on that point. But the point you put to Mr. Finlay was when he said operation of a farm, and he said operation of a farm can be nothing other than the keeping of livestock and the cultivation of land. And he said, what about a farm shop? I think he brushed over it quite quickly and said, well, that would be an ancillary activity. There is no such concept in the regulations of an ancillary activity. And I think Mr. Muir's made submissions on this point as to the difficulties and the risks of having such a broad descriptor of the authorised activity. And I don't agree with Mr. Finlay that the keeping the livestock is a direct equivalent to the operation of a marine pen fish farm. I think it is an equivalent to the operation of a farm. So I think it doesn't sit comfortably within regulations to have such a wide descriptor, because you do risk capturing a whole range of things, and the operator doesn't know where it begins and where it ends. And when
we had a discussion on that,
yeah,
but is the in terms of description, it broadens out. It does not broaden out existing description.
I think it takes it out of the ambit of the regulations. So.
Fair
Thanks, sir. I wanted to have a look at the regulations themselves. So if you could have a look at the bundle of legislation, and the place that I wanted to start should, I think, be page 545, which is the explanatory note.
electronic pages then?
Yes, it is. It's got 4 numbers on it. So 615-161 in the top right hand corner. It's page 545 of 746 if you're using the PDF tool in the bottom corner.
Oh, sorry. It's the bundle solution. Sorry.
Yeah, apologies. It's in the document's called a list of legislation for preliminary hearing. Closer. So page 545 should be explanatory note. And it does say it's not part of the regulations, so we'll look at regulations in a moment. I thought it was a useful starting point because it explains how the regulations are intended to work. So part what you'll see, second paragraph, part 1 of the regs setting out the scope and application of them. Part 2 of the regulations, quite important, describes the authorisations which SEPA may give and which are necessary to avoid breach of the prohibition in Regulation 4. The variation provisions, if you turn over the page, are found in Part 4 of the regulations, which makes provision for the modification and termination of authorisations. And it sets out SEPA's duties to periodical review and so on. If we go back to Regulation 8, which I think will be page 395. Sorry, it's 392 of the PDF. So 8.1, subject to Part 2 of Schedule 10, SEPA may authorise the carrying on of a controlled activity under this regulation, subject to the conditions provided for in this regulation. So that sets out the power that SEPA has to control an activity using a water use licence. If you look at the preceding page, registration, very similar wording, subject in 7.1, subject to Part 2 of Schedule 10, SEPA may authorise the carrying on of a controlled activity in accordance with the provisions of this regulation. So again, SEPA's power to control or regulate a controlled activity, but in a slightly less formal way. And then similarly, on Regulation 6, controlled activity is authorised under these regulations if it's carried out. So those set out the provisions which allow SEPA to authorise controlled activities. If you go on a couple of pages to PDF 393, Regulation 10, power of SEPA to impose authorisation. If it appears to SEPA that, and I'll not go through the full list, you're familiar with it, SEPA may treat the activity as an activity in respect of which an application has been made, and may, as it thinks fit, grant an authorisation under Regulation 7 or 8. So again, it's referring back to SEPA's power to authorise a controlled activity under Regulation 7 or 8. If you skip forward to Regulations 22 to 24, that is EDF 406, I think. 22.1, whether or not as a result of a review under Regulation 21, SEPA may vary an authorisation granted under Regulation 7 or 8. It does not give the power to SEPA to impose an authorisation or control an activity under Regulation 7 or 8. It simply allows it to vary the authorisation for an existing controlled activity. And so we say that there is a distinction to be drawn between the powers of variation under Regulation 22, etc., which is in a different part of the regulations, and the powers that exist under Part 2 of the regulations, which impose the SEPA's ability to authorise controlled activities. The only other thing that I wanted to say in relation to question 3 was you had a specific question about what we had said on the imposition of authorisations. And you'd asked effectively what difference would it make if Salmon Scotland was to, or sorry, if operators were to seek interim suspension of imposed authorisations. The point being, SEPA chose to SEPA said, with controlled activity, so we're going to impose the regulation authorisation. At that point, operators are protected in the sense that they have an authorisation that allows them to undertake that controlled activity. I say we don't have the right to appeal against the imposition of that authorisation. There's nothing in the regulations that allows for that. So your right of challenge would be judicial review. Your question was, if you were to judicially review and seek interim suspension.
Oh, yeah.
Yeah. So you have the point already, I think. So it's highly likely that what would happen is the operators would seek a judicial review of the imposition, but would not seek interim suspension, and would probably seek undertakings from SEPA in the way that has done in other litigation, that it would not enforce the conditions pending the outcome of the judicial review. And what that would allow is for the operators to ask the court to consider the legality of SEPA's finding, in essence, that a hypothetical activity of fish farming without planning permission, which is what they're asking you to regulate here, was criminal, unless separately authorised by SEPA under Regulation 10. So that would be the test for the court. I think that is probably about all I need to say on that. Yes, I'm just looking at my notes. I think I've covered everything that I need to say in relation to that question. Unless there's anything that you've got an immediate response to.
No, thanks for asking that question. Yeah, that's good. Okay. Mr. Weaver.
Yes, I just have one or two questions that includes yesterday, and come back to repeat what others have said. And I think SEPA have analysed Regulation 23, and we haven't. 406, if we still have the legislation.
I'm curious.
As being the source of the power into various things. It is relevant with 23 and 24. Not so sorry, incorrect on looks in regulation 24, which is the test for a variation, which transport person or operator may apply to see for a variation of organization that's already under. And then the provisions of 11 through 15 apply. But then the obligation on SEPA is at sub 3. SEPA must either grant or refuse to grant a part application under paragraph 1. And if it refuses to grant the application, it's reasons for such refusal. So, in other words, the function of granting 24 is all within regulation 24. You have a duty to take a decision on the 24th. Yes. And that's the story of the power and beginning with a application that's been made. Then you have to go back to 22 to find the power to vary. Makes sense.
My thought was simply that you know, to me, 22 has the power to vary. And 23 was a kind of deemed application or procedure for deemed application, and 24 is a power for an actual application.
Well, 23 I think applies in respect of regulation 22.
Right.
Because it says certain regulations apply when it's considering variation of organization under regulation 22.
Right. Yeah.
So 22 and 23 go together.
And then
24 doesn't require for a power to vary 22 because it contains an obligation either to vary to or to refuse the grant. So hardly it's relevant if they relevant to how these three provisions interact. And I think it's what Section 8 is aimed at here. So there's no necessity to look for 22. It's there in 24. The ninth question, I think, was question of whether corporate does have an option of making a new application applying for a variation under 24. I think in practice, the option. My understanding is that operators would consult SEPA and would be certain pre-application discussions and to them we would proceed in the way that SEPA preferred. But I don't think there's a difficult in any choice of this. The other point I wanted to pick up to question 16. Right over to question 3.
yes.
And the question, look, I think by yourself is whether if there is no power to make decisions under regulation 22, it's just procedural error. And it's good to just treat it as new authorization imposed under regulation 10. We didn't understand brought in a question of substantial, which is so forth.
SEPA's position. Wrong. I think it's substantial prejudice. If it wasn't substantial prejudice.
Yeah, I think we've discussed this over lunch and our position is firmed up. We accept that if we embarked on wholly the then I think it would be within your powers to treat it if we'd embarked on the right. It would have been abusive.
That's very helpful.
Whilst we think your powers, I think someone's done it. Agree that's fine. That may have reached the limit.
Yes, I was submitted the regions as this imposed under regulation 10 the view to sign to the law whether laws are incorrect the way that can be done. would essentially shortly to ultimately see through the larger reason. I would think that the other things you can do at this stage really maybe to the huge time so client. So I think that's what I wanted to say about question 16. I think the majority of the other questions then I think certainly we just clear about our we consider it to insert a new control activity and the ways of variation. Explain also explain that variation can be is this full activity. There's a specific route. Minor changes as well suggested on my resolution of 22.
Is there a limit on that? It has to be essentially the same activity. Is the limit on sorry, is there a limit on the degree to which the description can vary?
Well, if it's an entirely different activity, then it seems to me that there was a spectrum that would be rather wrong side of this a big usually to which one I like to
So yeah.
Thank you, Mr. Simpson. Marie's response to this question is at section 4 of the November document. I don't need to take you to that, but it's in the bundle beginning at page 398 of the combined bundle headlines. Sir, that Marie's position is that SEPA won't add a new controlled activity by variation. Marie's submission is that regulation 22 can only be used to vary conditions, the principal position. And if we are wrong about that, even if it can be used to go beyond the variation of condition, it cannot be used the kind of fundamental change that would be involved in the addition of a new controlled activity, essentially for the reasons given by Mr. MacLeod and Mr. Muir. Now, the reason that Maui takes its principal position on what regulation 22 and 23 are for it is based on the wording of the regulations themselves. And Mr. Muir has done me the obligement of taking you to them just a moment ago, and our analysis is very much on all fours with his. So Maui's position is that regulation 22 is not a freestanding various position to be followed by two procedural provisions under regulations 23 and 24. But rather, regulation 22 and 23 go together, and regulation 24 is separate as an operator initiated variation. Regulation 24 means that various regulations are to apply when SEPA is considering variation authorisation under regulation 22. Those words do not appear in regulation 24 at all. Rather, there is a much broader provision in regulation 24 in relation to variation. We then go back to regulation 22, and what's said is that SEPA may vary an authorisation granted under regulation 7 or 8, and a variation under paragraph 1 may include removing, adding or amending any condition of an authorisation. Now, the questions that came back yesterday gave us some hints that the reporters might not be satisfied with the reference to the Wirral case that was included in the submission. At the point simply to be drawn, 2 points to be drawn from that, the kind of wording which is referred to in that case as indicating a non-exhaustive list doesn't actually include the language in regulation 22. Regulation 22 does talk about including various things, but it doesn't talk about without prejudice to the generality. It doesn't give any indication that it's a non-exhaustive list, which then leads to the next question, which is, what is the purpose of regulation 22 if it is not to give some indication of the constraints that are placed around the authorisation that may be granted under Regulation 22.1. It would be an odd thing indeed for Regulation 22.2 to say in terms and explicitly the variation can include removing, adding or amending a condition, but to say nothing at all about adding additional authorised activities, which might be regarded as the greater rather than the lesser kind of variation. And in my submission, when one looks at these provisions as a whole, one has to take 22.2 as indicating a constraint on the nature of the SEPA initiated variation that can be made under Regulation 22. And that is essentially the reason why we take our primary position that Regulation 22 is limited to the variation of conditions. As I say, if we are wrong about that, then in our view, we would have the fallback position that one cannot go so far as to add a wholly new activity. I think that deals essentially with the questions that were directed to Maui by the further questions that came yesterday. And just to pick up on question 16 of question 2, it's also Maui's position that if there was no power to vary in this way using Regulation 22, that's not a procedural error. It's a competence problem that goes to the heart the powers that SEPA has purported to exercise. I think those are the only things I wanted to add on question 3.
Okay, very much. And Mr. McLean.
Thank you, sir. Cook's answer to question 3 is that no location of marine and fish farm cannot be lawfully added as a new activity by way of a variation to an existing licence using Regulation 22. Cook's submission is set out at section 4 on page 499 of the bundle of written submissions. I adopt that written submission. I'm also grateful to Ms. O'Neill, who has covered the ground that I was going to cover, so I'm content to adopt her submissions as well. The only point I wish to make is in relation to the submission Mr. Welton made, the licence and what could be changed in relation to the licence. Cook's position is that in order to change the authorised activity, so section, I think it was 1.2 of the licence, you would require to do that by way of Regulation 10. I think as Mr. Muir says in his written submissions, the authorised activity under CAR is not a condition of the licence, it's the purpose for which the licence is granted. And if SEPA was to look to change the authorised activity, you could use Regulation 10 for that purpose if so advised. And it's not appropriate to use Regulation 22 to do that. Similarly, I adopt the submissions of Ms. O'Neill in relation to the specific questions to Mary, because those questions apply to. I should say, I adopt submissions of both Mr. and Ms. O'Neill in relation to question 216. And from Cook's perspective, this is an issue of competence, and it is not something the reporters can vary. The correct route would be to quash the notices and for SEPA to take the decision on US advised.
Thank you very much. I'll turn to Mr. Finlay.
Thank you, sir. So SEPA's primary position is that Regulation 22 is relevant. It's not restricted in any of the ways my friend did. And the suggestion that Regulation 22, subparagraph 2, somehow narrows Regulation 22.1 is respect flies in the face of authority, has no substance. The position is that Regulation 10, there are alternatives to Regulation 10 and Regulation 22. And the primary basis for choosing between the alternatives would be the existence of an existing authorisation. And as Mr. MacLeod pointed out earlier, Regulation 30 provides for the amalgamation, you skipped me the precise the consolidation of authorisations. So an authorisation it's clearly contemplated within the regulations that an authorization could apply to a number of controlled activities.
Well, if it's consolidated.
If it's yes, and so one way of looking at what their friends are proposing is that they're suggesting that SEPA should have issued a fresh authorization under Regulation 10 and then consolidated it under Regulation 30, or have the option of consolidating it. Whereas what SEPA says is, why do that when you can just vary the existing authorization? I mean, there's no logical reason for requiring SEPA to go through two stages when the provisions and the regulations provide for one stage. And it clearly makes sense to have all the authorizations for one geographical location, one document. So in our submission, there is there are alternative routes that the SEPA had available to it. Earlier this week, we lodged a further case, CUSAC, which I'm not sure has made it to the list of authorities. But at paragraph, just for your note at the moment, paragraph 28 is that if there are two ways of doing something, Lord Lead is giving a reference. And one way involves payment of compensation, the other doesn't. The local authority are quite entitled to choose the way it doesn't involve compensation. Now, that's a far harder case than this. In fact, I would say it's the alternative in this, because it is the most surprising submission to make that the remedy of judicial review is as effective as an appeal before review. Because on any basis, you can review the merits. And so there's no right of appeal under Regulation 10. There is a right of appeal under Regulation 22. There's a much fuller right of appeal under Regulation 22 as opposed to Regulation 10. And that should be a matter that is at least considered when taking into account the route to follow, because we would be cutting down the appellant's right of appeal if we proceeded under Regulation 10. They're going to be able to apply for interim suspension, but you know as well as I the limits of a power of a court in judicial review. It won't engage in the merits. You are being invited, if we're successful at this stage, to wade into the merits. There is a very significant difference under greater protection for the appellants in that circumstance. The other issue is cost. Just by way of very basic estimation, I'm told that in the very rough order of £200,000 would be the cost for Maui alone, if it had to pay for licensing under Regulation 10. And without disrespect to any of the appellants, if we'd chosen a route which asked them to pay those sums of money in respect of that, I mean, Maui obviously has a lot of fish farms. Whereas there was a route available where they didn't have to pay such sums of money. I would imagine if we hadn't taken it into account, we'd be subject to extreme criticism. And the fact that we've chosen a route whereby they don't have to pay a fee.
Just on that point, I mean, I only glanced at this and I didn't have it properly. Isn't SEPA in charge of setting a schedule of payments? I don't know if SEPA would have discretion within that, or set a different.
I haven't looked at that. I don't know the answer to that. But the basic point of principle is that there would be provision for a fee under one and not under the other. And the fact that you choose a route which is more favourable to the appellants is then a subject of criticism, seems to be slightly practicing. Likewise, as to the routes to judicial review, we say they're both open to SEPA, but there's nothing in the terms of Regulation 22, which limits the ambit of the power under Regulation 22. And if one could issue a fresh authorization to control this activity, there is no reason in principle why you shouldn't amend an existing authorization, bring the authorizations into one, so that can be dealt with under Regulation 30. In terms of the Wirral case, respect to my learned friends from Brady's, you were entirely correct. Paragraph 23 says this: if legislature wishes to ensure that its provisions are other exhausted, usually says so. And the second example is the following are included in. Well, Regulation 22(2) doesn't use that language, but it's very similar. It says may include. It doesn't say are limited to. In our submission, the Wirral cases, as we pointed out, response authority for the line we're taking, the line certainly two of the appellants are taking. We said something. I just refer you to section 9 of our initial response to the appeals, where we dealt with this issue. I'm not going to go there in detail now. I propose to pick up your specific questions.
Just before you go, see what it's called to Mary's so yours to fall back on is simply, there is something that can you can amend what's been authorised by change. You can't propose an entire authorisation or a different activity.
Yeah, I understood that to be our position, but there's no such restriction on Regulation 22. You could I come back to the point. If it, which appears to be accepted, you could authorise a new activity under Regulation 10, and then combine it with the pre-existing authorisation under Regulation 30. Why should you go through two stages when, on our open reading of the legislation, there's nothing that prohibits? I don't understand how M&O friends find an implicit limitation on the power within Regulation 22 to do in one step what they accept you could do by two steps. Yeah. So do the activities have to be at the same facility under Regulation 22 or just by the same license? Well, they need to be under the same authorization. The only limitation on Regulation 22 is that you're varying an authorization. So there must be an existing authorization that you're varying. If there isn't an existing authorization, if the existing authorization doesn't on the rise in this case, but if you were using the power under Regulation 22 to license or impose a different type of authorization on or adding a location in Arran when the authorization related to a fish farm on Mull, you might struggle in terms of reasonableness, in terms of whether that was permitted or not. But that's not the case we have here.
So if it was an authorization for point source pollution, then add the construction activity.
Yes, this is one of the issues that SEPA does not have a full answer to at this stage, because it goes beyond the ambit of these appeals, because certainly in these appeals, the variations are to the same geographic location and the same license holder. I can envisage there may be many more difficult issues in other appeals, but I'm not in a position to give you a definitive answer to that today. And your second point is entirely correct, and we had erred in our first response. We picked that up in our second response, but we didn't do so expressly. It picks up in if I do the paragraph, but we recognised in our second response that the same procedural provisions apply under Regulation 10 as they do in Regulation 22. But we didn't highlight that point, so I'm not surprised that it's resolved. So, question 3. Yes, we do have an option of choosing between Regulation 10 and Regulation 22. In part covered question 4. Question 5 was for Scotland. I effectively responded to that already, unless I can help you further. Question 6, I've dealt with the case of Wirral. Question 7 is one for the appellants. I note that different answers have been given as to the extent of your question of the response. Question 8, I accept the point that this is the Regulation 22, 23, and 24. That Regulation 24 doesn't specifically refer back to Regulation 22.
Yeah.
But in my submission, your analysis is it doesn't really matter whether that analysis is correct or Regulation 24 is freestanding. But in our submission, the better analysis is that Regulation 22 provides the underlying power, and Regulation 20 to vary an authorization, and Regulations 23 and 24 are procedural. So, and then our answer to question 9 is again one that SEPA do not give a digit, but there's
Then direct to the point. It was just I wanted to
preliminary view is yes, but that's a preliminary view that yes, they could do. I've answered question 16 under question 2 already. I've made our position clear on that, which is that you don't have, in our view, you don't have the power if you started down the route to completely change the procedure and go under the right route, albeit that the same procedural provisions would apply. No, I think that's like to cross the line of Europe.
So just go back. Sorry, we finished.
Yes. Subject to responding to the various, if there are any points.
Yes. So just going back to question 4, your position is essentially that those two matters set out, such as the license for the were the reasons for, among the reasons for SEPA not going down that regulation.
My understanding is that SEPA had an initial discussion as to the route, and the primary reason for going down Regulation 22 was that there was an existing authorization dealing with that operation, and therefore it made sense to do it by that route. My understanding is that's what they do with any other similar they were adding an activity in. But the points I've made about cost and appeal reinforce that, and arguably implicit in it. But I don't say that. I don't have instructions one way or other. I don't think that it's explicitly referred at the time, but the indication that has been given to me was that it went with the variation of existing authorization for the fundamental point that I say in the live SEPA submissions. The you're dealing with the same operator and the same activity.
Are you struggling to hear?
Yeah, we're struggling to hear.
No,
We might close the window, and I do apologise. I realise it's hot, but the noise of the traffic is really
It's quite distracting.
with
Sorry.
hearing.
Sorry, do you mind? It's not one of those things when you've got when someone's sitting beside you, it's really difficult to. I'll send Mr. Finlay down to the other end.
Just reiterate what I said, and my apologies to Ms. Hamilton. In summary, SEPA chose the route it did because of an existing license, same operator, same location, same full ambit of approach. But the other matters it's pointed to reinforce that decision.
Was there anything else that you missed that could catch on one? It is recorded as well, and hopefully the makers will work it.
Well, I need to respond to it because I've picked up all the points from my opponent's solutions.
Right. Mr. McLeod has a point.
Just two points, sir. One was in relation to the question of authorisations. I've now lost the page. In Regulation 2R, right? Which is 386 of 746 in the list of legislation. It really just emphasises the point making earlier on. Authorisation is a defined term. It means an authorisation under Regulation 6, 7 or 8, not an authorisation under Regulation 22, 23 or 24, for example. So that the power to authorise a controlled activity is contained within its regulations. And then just one point in relation to.
Sorry, can you just draw that out a bit further?
Yeah.
What was he?
Yeah, certainly. So my point from earlier was that Part 2 of the regulations is the bit of the regulations that you go to which contains the power for SEPA to authorise a controlled activity. The variation provisions relate to variations of the authorisation of existing controlled activities, not the ability to vary an authorisation of controlled activities to introduce a new controlled activity. Those powers are restricted to Regulations 6, 7 and 8, which, and the fact that there's nothing in Regulation 22 is telling, I think. And then the second point was just picking up on Mr. Finlay's reference to the Cusack case that was lodged, I think, earlier this week, or maybe late last week. Just two brief points. Page 19 of the judgment.
Can you just give me a moment to find it?
Yes, certainly. So it's production 104.
104. Okay.
Entire 19 or page 19?
Page 19, sorry.
Page 19.
Page 19 of 21, if you're just to check you've got it right.
Sorry, it's not showing you there.
No.
Do you have a paragraph number?
I do, yeah. Paragraph 58.
Got it, yeah.
So, interpretation of any document ultimately involves identifying the intention of Parliament, the drafter, or the parties. That intention must be determined by reference to the precise words used, their particular documentary and factual context, and where identifiable, their aim or purpose. To that extent, almost every issue of interpretation is unique in terms of the nature of the various factors involved. and then they go on to say that the court doesn't have a free hand. So just pausing there for 1 second, Mr. Finlay himself, when he makes his submissions about the definition of controlled activity, says that you might need to consider where different terms are found within the regulations, different parts and so on. And that is relevant to the question of how activities are authorised or not, as the case may be. But then just in terms of applicability of this case to our case, paragraph 62 at the bottom of the page that you're hopefully on, it sets out what the case was about. Each provision in the case authorises a highway authority to erect posts, and it tells you what section 66 did and what section 80 did. Now, our position is that this case is not relevant because Regulation 22 and Regulation 10 don't authorise SEPA to do the same thing. They authorise SEPA on the one hand to impose an authorisation, or on the other hand to vary an existing authorisation. So it's a different point to that which is covered in this case.
Well, to be fair, I think Mr. Finlay's point was if you have two powers that do the same thing, then you can use either of them. I don't think he was going more than that from it.
I accept. I mean, I think there's a difference of opinion between us as to whether the powers are available under provisions or not.
Yeah.
Just to, if I may,
Of course, yes.
so just coming in on that again, that's what your client said. Notice that the paragraphs of the regulations we're dealing with, 22, 23, 24, are only part 4 of these regulations, for which the heading is modification, determination of authorizations, right? Which again goes into the point of authorizations are made under 1, under regulation 6, 7, or 8. And I think Mr. McLeod may have taken you earlier, PDF page 546 of the explanatory notes. Admittedly, there's a limit for which you can give to explanatory notes. Regulation 22 is there on page 546 to give power to SEPA to review any authorization under regulation 7, 8. Regulation 23 makes provision for the procedure to be followed in such a regulation. Regulation 24 makes provision for the responsible person or operator in respect of an authorization to apply for a variation of it, and makes provision for the procedure to be followed in such cases. So certainly the exempted note appears to the explanatory note appears to see the two as distinct. So I think that's what I wanted to say about these regulations and the part of the where they've been found. The only other point that I wanted to mention deals with regulation 10 route. Regulation 10 is in part 2 under authorizations. So part of the regulations 7 or 8. And any power of SEPA to impose authorization. So 1 of regulation 10 is clear that if it's fit, what it does is grant an authorization under regulation 7 or 8.
Yeah.
So it's not a new power, if you like, not a new regulation under which the authorization is granted. It's just a route to granting one under 7 or 8. And it's one other point to make. It's all of this discussion, I think, is that at least that since what happens under 10 is that they're given an authorization, granted an authorization under 7 or 8, then the appeal provision of regulation 50 C would be in play. A person who is aggrieved by the terms and conditions attached to that person's authorization in accordance with regulation 7 or 8.
All right, yes.
See that. And that plays into what Elizabeth Hill said about regulations 22 and 23 apply to the ENVE conditions. Because the original provision C, which is plainly in plan, regulation 10 tells you you're back at 7 or 8 for the ground. 50C tells you that you're deep on it.
But only in respect of terms and conditions, not in respect of the imposition of license itself.
Which suggests that since this is through 20, well, not under 20, sorry, 20 now looking at yes, that's right. Terms and conditions.
Does the terms cover the description of the activity?
Well, I think it's me, isn't it? In terms of the authorization. And the conditions. Or terms would include anything else, information, description. And that's you see.
Could you, the Scottish ministers watch permission, an authorization that's about imposed under that provision?
I think if you can do determination 51.
Oh, yes. From the decision card.
And decision referred to a regulation.
So does that affect submissions that we made about judicial review? May this be a remedy for judicial review? The appeal under section 50C. If you took, if you've got authorizations under regulation 10.
When the authorization under some words for see.
That would be the remedy.
Others may have something to say.
So if the way that I read 51, just one thing that your powers are to affirm the decision or any part of it. So if SEPA imposed an authorization under regulation 10, you have the power to affirm it. If the decision was a refusal to impose an authorization, well, that doesn't apply in this case clearly, because if SEPA hadn't imposed the authorization, we wouldn't be here. If the decision was as to the conditions attached to an authorization, quash or vary all or any of the conditions of the authorization, that might be relevant, but the fundamental point is that the industry does not believe that this is an activity that requires an authorization at this stage. So your powers under 51C are limited in the case of an authorization that has been imposed to dealing with the conditions only. You can't say, SEPA, you have imposed an authorization and we don't believe that you should impose that authorization under regulation 10. That, on my reading, would be a power that is reserved to the court, not to Scottish ministers.
I can't come back on that. There may well be force in Mr. Moore's point, which my understanding relates to paragraph 50C, that a person is aggrieved by the terms and conditions authorization in accordance with regulation 7 or 8 can appeal. Terms and conditions is very wide. That would be everything. If SEPA was to says provisional view, so we haven't discussed it, but if SEPA were to exercise its power under regulation 10, they do grant an authorization under regulation 7 or 8. That is so that would engage 50C, and then the determination of appeals would follow from that. Obviously, your powers in this appeal are under 51E. So there's
Yes.
but you can affirm the decision. For very any condition too, you could certainly remove any conditions relating to, for instance, sea lice. But it may work. It's not. There seems to be some tension between the position adopted by Mr. McLeod and that adopted by Mr. Muir. But I can see the force in Mr. Muir's point that there may well be the powers of appeal under Regulation 51 are definitely meant to cover the terms, should be able to cover the terms of an authorization in accordance with Regulations 7. But it doesn't. Yeah. But it doesn't. That doesn't impact on our primary exhibition.
Does anyone want to raise anything further in respect as to those submission of appellants? Mr. Finley's submission of the appellants. Should we? Okay. So nothing further you want to add in this question. Mr. Welcome, you're looking for
No, I was.
right. Okay. Well, I'm due to move on to question 4. We've got 3. Make start on this. Yeah. Okay. So I'll start with give the appellants the first word again. I think I'm on to Mr. Cloud.
I actually have very little to say in response to this question because looking at the various sub-questions, the vast majority of the questions are for SEPA to set out its position. And I prefer to reserve my position to respond to that once I've heard from them. I think just one observation in response to question 4.4. And what you've said there is SEPA's acknowledged that on its interpretation, those operating a marine pen fish farm without an authorization have been committing an offence since the introduction of CAR. It actually goes a bit further than that. And if you have a look at Regulation 4 in CAR, I'm sorry, I don't have the page number to hand.
With the electronic, the online version comes from easier.
PTA.
389. Thank you very much. So page 389, prohibition. No person shall carry on or shall cause or permit others to carry on any controlled activity. So does that apply to the Crown Estate who granted the leases to operate the fish farms? To the planning authorities that granted planning permission? To SEPA officers who have been attempting to do us a favour since they changed their position on significance of impact? It's quite a broad provision, which again, I say demonstrates the fact that the route that SEPA has gone down here was not the right route to go down in the first place. And I think the only other point I had, which is also a regulation point, you'd asked, does CAR Regulation 8.5 provide any guide to or restriction on the matters which SEPA must or may have regard to? And I think the answer is no. 8.5 appears to deal with a situation where SEPA is considering potential cumulative impact. So it deals with a particular situation, but it's not a limiting factor. So I don't think in terms of things that SEPA must consider.
Yeah, no, the reason I was asking the question was because I think this was point made by SEPA referred to discussing
Yeah.
the assessment of significant impact referred to this provision. And the way I read that provision was that these are matters that need to be considered when whether to considering when granted authorization or in SEPA's considering whether to grant authorization rather than when assessing significance. But the literature seems to be coming back on that.
Yeah. And those are the only comments I have at this.
Okay.
Yes, I have little I want to say at this stage. There are obviously possible responses I might wish to make once I've heard on SEPA sense. Just in the references we deal with question 4, section 11 of the amendment, but then finally section 5 of the SEPA response to others. Seems to be the answer at 4 about the compatibility with narrative structure, but it's not covered. 5, the important site SEPA's got 81, which refers to relation. Yes, I think does fit SEPA's implementation of 1G. I think it's probably still high. My only values to many commentators. These are actually questions for SEPA.
Mr. Seaton, sorry, the short answer from Maui to question 4 is that yes, SEPA must have regard to the extent to which the impacts of an activity are already subject to controls and mitigation under other regulatory regimes. That's set out in detail in Maui's 24 November document, which is at the bundle, page 4.2 onwards. The short point, sirs, is that it's a plain principle of administrative law that a regulator such as SEPA must have regard to all relevant facts that may be pertinent to its decision making with regards to case law to that effect. I would agree that Regulation 8.5 does not exhaust the relevant considerations to which SEPA should have regard. And I read SEPA's response to this question as being effectively maybe or sometimes. So it's a matter of SEPA's discretion whether it takes account of other mitigation when it is dealing with CAR 31G. The short response to that is if it is a discretion, then like other discretions conferred on SEPA, it must be exercised appropriately, having regard to all relevant and disregarding all irrelevant considerations, and mitigation is clearly relevant in our. But like my like the representatives for your appellants, I'm conscious most of the questions here are direct.
Cook's answer to question 4 is yes, and I would also adopt submissions that are made on behalf of Cook. Just so you have the page reference, those are in section 5 of the 24th of November submissions at page 503. Like the representatives for the other operators, I would reserve my position in relation to the other questions of SEPA's response, and those questions being primarily questions for SEPA to answer.
Likewise,
Okay. Well, Mr. Finn, will you have the floor?
Thank you, sir. Yes, I've dealt with this. This question comes at a similar issue to which I spent some time on when answering question 2. And so the question is whether we're still at the purposes of definition of whether we fall within 3.1G or not, rather than whether how we take decisions under Part 3 of the regulations if it is an activity which needs a license. So I'm coming right back to question 1. Our response in respect to question 1 or clarification with respect to question 1 and question 2 was that you consider the activity without regard to any mitigation whatsoever. So in response to the submission that it's a principle of administrative law, you take all relevant factors into account. Indeed, it may be a factor that SEPA should have regard to in particular certain circumstances when granting an authorization and or imposing conditions. But when identifying whether an activity is likely to have a significant adverse effect on the water environment, in our submission, SEPA is required to consider that without regard to mitigation, as I've indicated earlier. The question 2, which deals with regulation 8.5, which arises from our 5.2 on November response, we refer to 8.5a as something we're required to have regard to when we're considering whether to grant an authorization or impose conditions. It's not arguably perhaps was irrelevant to that question in hindsight, because the question is about whether it's an activity that could be authorized. So paragraph 5.2 is assuming it could be authorized. So my apologies for that red herring at that point. But
Wanted to check.
yes, no. I come back to the other. In answer to question 3, I simply reiterate the points I've already made about SEPA being lead regulator and the other controls being expected to be removed. As to question 4, I think I've dealt with that under question 2. It arises saying it's the double penalisation. It's the same good project cases. I've made my submissions on those cases unless you prefer what you wish me to deal with. I'm grateful. Then under question 5, we refer to our sea lice regulatory framework, para 81, and that is in our submission dealing with the regulation 15.1a assessment rather than whether an activity falls within regulation 3.1g. That's the purpose of the that part of the
So essentially that's when SEPA is concerned, it's concerned with whether it will require procedure.
yes,
Right.
and also what conditions to impose. And also what conditions. I mean, all those matters, once you've got an activity where you think there should be an authorization, then you deal with those matters under essentially part 3. But if controls are in place that cover the same thing, then as a matter of basic principle, you perhaps have regard to them. But knowing that the regime is changing and the license you're putting in place is meant to exist for the future absent those controls, then you have to look at matters without regard to them, in the sense that their existence, if you took their existence into account, you'd be taking into account a consideration that would disappear. I don't think this is appropriate administrative law language, but it would be undertaking your review of conditions on a false premise.
Well, would you not be taking should you not take this on the basis that it will go something on, but it's there.
But there is no direct correlation between SEPA have to but straight answer that is no, because SEPA, having been told that they are going to be the party responsible for the interaction of sea lice from marine fish farms and wild salmon and sea trout, it would be acting in derogation of that responsibility to leave the control to somebody else. That's an effect.
Making it sound like a matter of choice, though.
I don't believe there is a matter of choice. And if SEPA are putting in place a license that is to exist in the future absent such controls, they should not take those controls into account. And in any event, there would be the only the two further matters. Firstly, those controls go beyond those the controls and the EMPs at present. We've made that point elsewhere. I can't put my finger on it at the moment. And secondly, even if you were persuaded there was any force in this point, you should simply vary the license to prevent those controls coming in force until the EMPs were removed. But in our submission, there would be no justification for doing that. I've taken you to document 2 already, but I would remind you of the SEPA production 2, which you refer to in question 7. The Scottish ministers say we agree bus conditions based on adaptive management approach to safeguard wild salmonid should be contained within a license in a planning condition. That's a quotation from taking you to documents, but I didn't take back there. But and that they should be applied to existing as well as new fish farms. In our submission, that is effectively required to comply with the Water Framework Directive. There should be clear control handed. As I said earlier this morning, it is not for SEPA to SEPA is not given control as to the how EMPs are authorised once their licence come into force. For planning authorities and the Scottish ministers.
Are you struggling to hear?
Oh no, sorry, I'm maybe looking perplexed, but
She's one of many people that vexed at my solicitors. So I think I would be repeating myself from what the submissions I made this morning, but in terms of our answers to your further questions. In response to what from Mr. McLeod, it comes back to Regulation 4 and the width of it. I've dealt with the criminal liability already, but I simply say this in respect to that. If it's accepted that there is a harm which needs to be dealt with under the regulations, Regulation 31G, only regulation under which it's dealt. I made that submission. No one rebutted it. Therefore, the only way of dealing with that is by way of an authorisation which covers that activity and conditions being placed on it. No one can argue about the precise terms of the activity, argue about
Thank you. The point I was making there was that EMPs are just one element of the landscape that may exist. Even if EMPs disappear, planning consents will continue with other conditions attached to them. But beyond that, sir, it's Maui's position that the mitigation, the relevant mitigation to which, as a matter of law, SEPA ought also to have regard, is mitigation undertaken voluntarily by the operator. Maui would make the submission that it puts in place a range of management measures which are real, which are being given effect on a daily basis, and which, as a matter of law, ought to be had regard to when coming to a conclusion under Regulation 3.1g. And in my submission, SEPA has not pointed to any legal basis on which it can justify disregarding that relevant material. Those were the points I think I wanted to come back on. Sarah, if you give me one moment. I'm being taken to SEPA's production 86. Production 86. Sir, whether I can get that from Objective Connect, I'm not sure I can, but we're looking at page 19 of this document.
It's not followed up through on
It's the letter Ms. Goujon,
right.
and it is what's one page document.
Right. I've got it.
26. I'm sorry, page 19 of that document. And this is a response of the Scottish Government to the Parliamentary Committee in relation to the risk posed by sea lice from fish farms. So about a third of the way down the page under paragraph 237 response. And what's said is that the Scottish Government set out that the risk posed by sea lice in fish farms is not solely predicated on proximity of salmon farms to migratory routes, but influenced by the farm's location, the number of fish on the farm's sea lice management measures, etc., etc. And the point is simply that the government has acknowledged that the management measures that are taken by the operator themselves is directly relevant to the question of risk. And of course, risk is what SEPA is dealing with in Regulation 3.1g. I don't think I have any other points I'm being asked to make.
Mr. McLean?
It's just a short.
Did you want to
Well, there are a couple of points I want Mr. McFadden.
well, perhaps
Yes, right.
go first.
Just a short point. Question 4 is directed at when deciding if an individual activity has or is likely to have a significant adverse impact on the water environment for the purposes of CAR 3.1g. And its answer in its written response was, in SEPA's view, the answer is no, there is no such requirement, and that's consistent with the submission we've heard this morning. But it then goes on to say, may do in appropriate circumstances. I'm not, unless I'm missing thing in the submission, I'm not clear as to what SEPA's position is, as to what are the appropriate circumstances in which controls and mitigation from other regulatory regimes are taken into account at the stage of 3.1g. And it seems to me in the submission, and if those controls and mitigations are appropriate at the second stage, they're equally relevant and appropriate at the first stage of the analysis because they are the same controls and mitigation. They don't change when applied at stage 1 when they're applied at stage 2.
Well, perhaps before I go to Mr. Welton, well, I'll take this 12th point and then switch on back to him.
Thanks, sir. Sorry, a number of short points. And it's really just for the benefit of SSF. in terms of not losing sight of the reality going on here and the situation that my clients find themselves in. This really talks again in the abstract about the assessment of impacts. And I'd just like to stress that when SEPA say that, what they've assessed is a generic activity. That's 229 of their submission. Now, I would submit that all of these appeals relate to existing authorised fish farms, the vast majority of which are operational. To borrow the language, it's somewhat absurd to ignore the performance or the impacts of real life operating fish farms in favour of a generic fish farm, the terms of which we know nothing about. We don't know what size it is, we don't know how it's been designed, we don't know what inherent mitigation it might have. And I think it's absurd to substitute out a real life situation for a generic one, which is in the minds of SEPA, but not shared with anyone else. And the difficulty with that from our client's point of view, of course, is they are operating their fish farms in accordance with their existing licenses. SEPA's position from the outset of this process has been, they say, well, this obviously isn't accepted, but they say the imposition of the variations do not change how those fish farms would operate from the day before to the day after. So the fish farms, by definition, are not currently having a likely significant impact. And yet, they find themselves the wrong side of Regulation 4. And there's just one additional point on this I want to pick up in terms of a point Mr. Finlay made about suggesting that as the EMPs are, as he says, phased out, although that's not something over which SEPA had any control, and conditions, and I think he was getting to the reporting conditions could somehow be put on hold until that happened to avoid the duplicate. Reporting conditions, so the salmon farms in the Northern Isles, etc., is that they trigger 3.1G without these conditions. So if the conditions are put on hold pending the phasing out of the EMPs, 3.1G isn't triggered. There's no, if you see what I mean, they're putting the conditions on hold. To take a step back, they're saying without these conditions, 3.1G is triggered. But they're now saying if you want to avoid a duplication of regulation, you can effectively make those, I suppose, suspensive conditions. Which begs the question, how is 3.1G engaged at all? And I've not managed to take that any further on my own thoughts, because I've only just heard it. The other point in terms of the reporting conditions and 3.1G, I think is relevant to that submission is at page 214 of it's SEPA's response to the question, so it's in response to question 6. It's the response to November, 24 November.
Response from this question 6.
Yes, so it's page 22. So no, with what? And if you have that. I understand SEPA's position here, and they are accepting that the monitoring conditions will not remove the likelihood of a likely significant impact, and they rely on the existing conditions. And I referred to those in the example license from earlier. The location of the fish farm, maximum biomass, and harvesting, restocking, and the fallow rate. So they are not correct to say that 3.1G is the only way of addressing likely significant impacts, because SEPA are saying themselves that they're relying on these pre-existing conditions imposed through 3.1A to address that impact. SEPA saying that
only as a side effect.
Pardon?
Only as a side effect of regulating other activities.
Well, it is something that SEPA consider themselves able to do. Now they're saying, as I understand SEPA's position is that imposing these conditions is addressing impacts relevant to the impacts of sea lice on wild salmon. Sorry, their position is that the reporting conditions don't do anything themselves, but you have to read them in conjunction with the pre-existing conditions imposed under 3.1A, and that gives you an overall position.
Yeah.
So and I would suggest that of those controls, the monitoring element is probably the least impactful in terms of operation. And I was really just to pick up on Ms. Finley's point about 3.1G being the only, particularly in the context that SEPA are saying you can put these conditions on hold, because they're saying if that's right, on the basis of what they say here, then the controls to address a significant impact are already catered for.
Just having for you to invest this in 5 minutes.
Oh, yeah, hopefully. But yes, if I deal with Mr. Welton's closing points first, he is utterly confusing the stage at which you identify an activity control with the conditions you might place to undertake that control once you have the activity identified. So that the fact that when we are imposing conditions, taking into account other conditions that are imposed already, is wholly sensible and reasonable and proportionate, but that doesn't impact on whether the activity itself is an activity which is likely to have a significant impact on the water environment.
So, of course, your position is that even SEPA's conditions are ignored with the
Absolutely.
3.1G. Right.
So, coming back to Mr. McLeod's points to begin with, he referred again to the document Mr. Muir was to submit, and no doubt will be treating this what it has been handed up to you. But can I refer you to, he reiterated the point, we're still looking for evidence, which is a point he made in his response by reference to a comment from Lynn Bunton. And we responded to that in paragraph 2.2.1 of our December response, saying it was taken out of context. And we say absolutely the same about the document that he's just put in. He is, with respect, taking answers out of context, which are not an admission in any form by SEPA that its underlying concern is not a concluded position. His next point was that we've reached absurd consequences using the route ban. The Scottish Government, in their response to SIWG Group's recommendations, says the Water Environment Controlled Activities Scotland regulations establish controls over specified activities likely to cause significant adverse impacts on the water. they clearly, Scottish government clearly is that regulations in that unamended form do that. And if we are being absurd, so are they, and so are the SIWG. His next point was that why didn't we just amend Schedule 3, define an activity, and subject to general binding rules? Well, firstly, that suggests that it's an activity that is appropriate to be dealt with under general binding rules. We've heard no submissions from Mr. MacLeod why that should be the case. Or fundamentally, there is no difference in principle. We still require an activity to be identified. So, for sake of being contentious, if we amended Schedule 3 to have an activity which identified marine pen fish farming, we'd be in exactly the same position as we are today. The activity would have been identified in Schedule 3, the activity would be identified in a license variation. There would still be the same complaint about the nature of the activity identified. People might provide an alternative. It would make no difference in principle.
Wasn't the other point around the date when that would kick in? It would be restricted.
Well, in terms of it being retrospective, I accept the point that there is theoretical potential for this to be retrospective. I say that if that was the case, then every new activity would have to be any new activity under 3.1a or 3.1g could be retrospective depending on the state of knowledge. But Schedule 3 is defining activities that are only then subject to general binding rules. If it was considered to be an activity that required more precise, less generic identification or conditions than general binding rules, then it wouldn't be appropriate for Schedule 3. And it's the first time I've heard anyone from the opponents suggesting that it would be appropriate to identify what they're seeking to identify by general binding rules. That's the purpose of Schedule 3. I've gone to Schedule 3 for the purpose of illustrating how activities have been defined in different parts of the regulations, not as an alternative way of controlling those activities. So, with respect, in our submission, Mr. MacLeod's point is wouldn't avoid the definitional issues that he's concerned. It might avoid the retrospectivity that he's concerned, but it doesn't. No one has suggested to SEPA that this is, until Mr. MacLeod has done so this afternoon, that this is an activity that is appropriate to control by general binding rules, as opposed to, i.e., under Regulation 6, as opposed to Regulation 8. Indeed, the thrust of the submissions on the last question was we should review Regulation 10 or Regulation 22 if you were to do it at all, not go Regulation 6, or indeed Regulation 7, which would have been an alternate halfway solution between the two. So it's a new point, and certainly, insofar as I'm able to answer it this afternoon, it has no substance for the reasons I've indicated.
So, Mr. Vice Chairman, is that a representation of your position?
No, I don't accept it's a new point. If you look at
Is that the one beginning in my appears?
no, it begins to illustrate the irrationality of SEPA's approach. a few paragraphs that begin that way. 4.4 on page 5. It's electronic page 18.
So my apologies, sir, I'm not there yet. Which?
It's the submission of 24th November.
From Scottish Sea Farms?
No, response for Salmon Scotland adopted by Loch Duart Claims and Organic Sea Harvest. Sir.
Yes, sir.
That paragraph specifically identifies Schedule 3, spells out the approach that SEPA took using its powers under PAR to amend the regulations in 2021 to provide terrestrial farmers with certainty that with effect from 1st January 2022, activities would have to be conducted in a particular way. Now, all of that is put in the context of what we say before about the lack, we say, of evidence of any likely significant adverse impact. The fact that we're in a position here where these provisions apparently do have retrospective effect. SEPA's saying they won't enforce and they won't take, I think the line in their submission was they wouldn't refer the matter to the Crown Office at least until the end of these appeals. It's hardly a ringing endorsement of a solid regulatory position that SEPA's having to give, make submissions like that during this appeal, when there was clearly an option that could have been available to them. And I don't accept what Mr. Finlay says about we'd have been in the same position. We would have been in a position where Parliament could have debated the precise terms on which fish farms should be regulated, not having a situation where fish farms were shoehorned into a situation where they were criminal with effect from 1st February 2024, when those, and this is the important point, there was no change in activity between 30th of January 2024 and 2nd February 2024. What happened was that SEPA decided, or maybe was told, that it was to take responsibility for regulation with effect from that date. The activity did not change at all. And yet, SEPA says, with effect from that date, simply because it was told or decided to become responsible regulator, the activity was criminal. Now that is absurd. I'm sorry.
With respect to Mr. McLeod, nothing in paragraphs 4.4 or 4.5 suggests that the activity we've identified should be dealt with under the general binding for the terrestrial farmer. He's taken that point and run with it for his subsequent submissions.
To be fair, I think you can't say it's up to SEPA to define what the activity is.
Absolutely, we have the same definitional point under each instance, but I've dealt with my point on retrospective position. It won't get better through repetition. And hopefully the appellant's point doesn't either. Mr. Neal made the point that the Scottish Government approach cannot affect the matter of interpretation. Matters of interpretation is a matter of law, and I agree with that. But that wasn't my point in referring to it. Mr. McLean correctly pointed out I hadn't answered question 1.
Sorry, just want to say what your point was.
Yes, that when that was primarily to do with the timeline about why SEPA has not taken into account other regimes, which is an issue which will arise in 2 instances. First, under 3.1g, we say, in fact, you don't take into account any international provisions at all. but it would also arise under the terms of the license, which we'll be coming on to. And because of the way the debate has gone, it's necessary to answer both of those. But that's why the point as to timing is relevant to 3.1. It is relevant, but the SEPA's need to take action, which appeared to be being called into question, comes as a result of the Scottish Government saying you are going to be the authority. So that's why you start taking action, why you have to consider whether the regulations apply. It doesn't alter the interpretation of the regulations, except for time. Mr. McLean referred to our rather enigmatic answer to question 1. The example I've given is that up until 2020, relevant discharges of fish medicines from well baits were dealt with under the Marine Scotland Act and excluded as a controlled activity under CAR. And that would be the type of matter that you would have regard to.
I'm certain I'm not following that submission, and I just now so that Mr. Finlay can address it. I don't know what's being said about that being something that would be had regard to, and why that's different from submission.
Yes, I'm very happy to explain it to my friend. If another act says that a particular operation or even activity is not a controlled activity under CAR.
So the Marine Scotland.
Yes, that's my understanding. Yes, those are that is the example I've been given. I must admit I haven't had time to follow that up myself, check it, but those are the instructions I'm given as to why SEPA is probably the way it did.
If you could, for this year, we'll probably be able to look at the Marine Scotland Act possibly putting this particular discussion.
I may re-emphasise the point. It was prior to 2020. That's the position. So,
They have the provision of the Marine Scotland Act.
Can I do that outside the inquiry? I certainly can't give it to Mr. Wilson at the moment, for the reasons I've just indicated.
Well, just does someone from SEPA have it, so we can maybe.
Well, we'll provide it out of the inquiry time as soon as we can.
We can take that in the morning. Yeah, we'll take it in the morning.
I'll seek to provide it this evening if we can. So, research can maybe laid out and done.
Right. And then the other parties. Well, we're at 4:20 now. These others are allowed so you to get a meeting, and I think everyone's probably getting quite tired now. We're going to let it for 2 hours, 20 minutes. Mr. Walton, were you wanting to say something?
No, okay. I'm doing that.
Mr. Walton's already rocking, so I think although it's that slightly brutal cut off of this particular debate, we will have to resume it tomorrow. I think we'll close there and resume tomorrow. We could do tomorrow at 10 o'clock. I think 10 o'clock. Yeah. Okay. Great. Okay. Well, thanks to everyone today. So it's rather warm in this room. That's thank you very much.
Thank you.
Like me and Sam to swap my sequence.
Actually, that might be helpful if in terms of, because obviously you're speaking about half speaking, so it might be helpful if you're down there and you're further away, naturally project a bit better. Or perhaps that's the thing to do. Yeah. Okay.